welcome to everybody. I hope that everybody, the line is clear. Welcome to everybody today to this international workshop on business human rights that Italy, under the Italian presidency of the Council of Europe, has organized together with the Council of Europe. As you know, I am the president of the Italian Interministerial Committee for Human Rights and also special envoy for the human rights of LGBTQ+ persons. It's a pleasure for me to welcome you all. We are very happy that this workshop is taking place today, and it's a moment for us important for thoughts, for reflection on an issue that is particularly dear and important to Italy and to the Committee for Human Rights. I'm really happy of the high-level participants, and of course we hope that today it will be a very interesting discussion, and it will give us some thoughts also for the future. First thing, I will ask for the opening remarks. The Italian Undersecretary of State, Honorable Benedetto Della Vedova, Undersecretary of State in the Ministry of Foreign Affairs and International Cooperation, to open this workshop with his opening remarks. Honorable Benedetto Della Vedova, the line is yours.
Deputy Minister Della Vedova is coming. Just one minute, he will be with us.
Perfect.
Thank you.
I see. Is muted, bisogna dargli la parola.
I'm ready.
Welcome, Honorable Della Vedova. The floor is yours. Thank you so much to be with us.
Thank you very much, Mr. Petri. Dear representatives of the Council of Europe and the international organization convened today, dear speakers, dear guests. I'm glad to extend to all of you the greetings of the Italian presidency of the Committee of Ministers of the Council of Europe at the opening of this workshop on a topic that has assumed an increasing relevance for the promotion of the human rights. In this regard, at the outset, I would like to reiterate my belief that the Council of Europe is a fundamental forum for consolidating a collective commitment in this area, representing an ideal framework for dialogue on values and principles that are closest to our hearts. Having such a forum for discussion, which is featured by a strong multilateral vocation and extends beyond its borders, is becoming increasingly urgent and important in such deteriorated international climate and on major issues as peace, security, and legality. As we all know, our continent has a well-established tradition of promoting these values. even though we are currently witnessing one of the most serious humanitarian disasters in Europe since the Second World War. Certainly, the repugnant war of aggression waged in Ukraine by the Russian Federation could plant our faith in dialogue and progress, especially since it's a conflict that appears to be totally unjustified and unjustifiable, and contrary to all the most basic norms of international law and considerations of humanity. It is precisely for this reason that, especially today, it is essential that we continue to demonstrate our convictions and our resistance. The terrible suffering of the Ukrainian people must therefore spur us on to renew our commitment and rebuild confidence in a world founded on democratic principles, the rule of law, and respect for individual dignity. In other words, all those principles which create conditions for establishing political systems that are conducive to peace. This was the main objective of the founding members of the Council of Europe, including Italy, in the aftermath of the devastation of the Second World War, and many other countries have joined in over the years. Hence, with the horror of war so tangible and close at hand, it's our duty to remain committed to this obligation, its conventions, and its legal instruments. In this context, even a relatively new topic such as business and human rights takes on particular relevance and international interest. We all know, in fact, how much the role of business can affect various aspects of development and, consequently, also living conditions of individuals and societies. In every member state of the Council of Europe, Italy included, business contribute to creating wealth and collective well-being, but we are also aware that each of their activities or development programs along the entire production and supply chain can have a significant impact on various economic, social, and environmental aspects. In light of this, the Council of Europe, like other major international organizations, is actively contributing to the better implementation of the United Nations Guiding Principles on Business and Human Rights. From 2011, these principles have provided for a more innovative vision on the protection of human rights, linked also to the 2015 Sustainable Development Goals and the 2030 Agenda. In this framework, Italy also has made an important contribution, adopting a first national action plan on business and human rights in 2016, which, just last December, has already been renewed for a second 5-year period. On the occasion of the second plan for 2021-2026, an attempt was also made to update the context and objectives of this commitment, deepening many aspects concerning, for example, the protection of the environment, health, decent work, and human rights defenders, as well as other aspects related to the new technological and digital challenges. More and more today, we have to take into account, among others, the possible implication of the gig economy on the developments in artificial intelligence, the algorithms. Of course, we are well mindful that this topic is constantly evolving, and also for this reason, the Italian plan has now introduced specific indicators in order to facilitate the monitoring and evaluation of the results achieved during the next implementation period. We hope that today's workshop will help us to discuss a series of priorities and objectives with a view to consolidating good practices with possible international relevance. Beyond the outcomes of this event, we believe it is crucial to pay increasing attention to the business and human rights, not being a secondary topic, by institutions and businesses. Today, we are all called upon to adopt increasingly conscious and responsible responsible conducts in line with the highest standards of protection of human rights. This is key if we intend to strengthen a collective vision that is culturally and socially sustainable, aimed at hindering all forms of violation and abuse, both for the benefit of present and future generations. In thanking for your participation, I wish you all a good work. Thank you.
Thank you, Honorable Della Vedova. Thank you to the Italian Undersecretary of State in the Ministry of Foreign Affairs and International Cooperation for your words and to be with us today. As we know, this is a workshop organized together with the Council of Europe. So now I will give the floor to Mr. Christophe Poirel, Director, Human Rights Directorate of Council of Europe. Mr. Poirel, I hope that you are online with us. The floor is yours.
Thank you very much, Mr. Petri. I hope you can hear me. And first of all, I would like to say thank you very much. Good afternoon to all participants. And thank you very much, Minister Della Vedova, for being with us this afternoon. We appreciate it very much, I must say. Your Excellency, ladies and gentlemen, it is an honor and a privilege, I must say, for me to be here today with you to address the opening session of this important and timely workshop on business and human rights. As a representative of the Council of Europe, I'm particularly pleased that the Italian government has chosen the theme as one of its priorities during its presidency of our Committee of Ministers. During the last decade, a growing appreciation of the actual, but also I would say the potential impact of business activities on human rights has led to important developments in international and national standards. The cornerstone is the text that you just mentioned, Minister Della Vedova, the UN Guiding Principles. Building on the so-called Protect, Respect and Remedy framework, the guiding principles, which were originally developed by the special representative of the UN Secretary General, were endorsed by the UN Human Rights Council, as you indicated, in 2011. The Council of Europe, I must say, responded to the United Nations groundbreaking work by taking complementary action to promote implementation of the guiding principles at the European level. Firstly, in 2014, the Committee of Ministers of the Council of Europe adopted a declaration on the UN principles on business and human rights, expressing its strong support for the principles and calling for action under each limb of this framework. Beyond that, in 2016, the Committee of Ministers went further by adopting Recommendation 2016-3 on human rights and business. The 2016 recommendation has, I would say, a much more practical, operational purpose. It calls for a review of national legislation and practice in accordance with a series of principles and guidance set out in the appendix to this recommendation. It also contains recommendations for awareness-raising measures, and I think awareness-raising is quite an important dimension of the topic we are going to discuss this afternoon. So it also contains recommendations, as I said, for awareness-raising activities, the sharing of good practice, and a decision to review the implementation of the recommendation within 5 years. So when the recommendation was adopted by the Committee of Ministers, the idea was not simply to have a new international text, but it was also, the purpose was also to make sure that our member states in the Council of Europe would take concrete steps to implement the recommendation, and thus that's where the review is coming into place. The Steering Committee for Human Rights, which has drafted the Committee of Ministers recommendation, carried out this review between 2019 and 2021. It appointed a special rapporteur to prepare its report, and Mrs. Nicola Wetzel of Germany, who will be addressing you shortly, will tell you more about this process and its findings. The full report, which is a significant piece of work of almost 50 pages, is available on the website of the CDDH, the Steering Committee for Human Rights. The Committee of Ministers' recommendation also called for the creation of a publicly available, accessible information system for sharing examples of good practice. I think in this area, like in many others, sharing good practices, sharing example of what can be done at national level is certainly most useful. And the establishment of this platform took place in 2019, again under the aegis of the Steering Committee for Human Rights. This online platform enables member states to provide information for publication on a specifically created web page. It presents national action plans and related information received so far from 21 member states, including Italy, but also we'll have with us this afternoon representatives of 2 other countries, France and Germany. So action plans from those 21 member states, as well as standards and guidance from various international organizations. The platform itself can be found via a link on the website of the CDDH. But our work on human rights and business will not stop there. As you said, Mr. Della Vedova, there are many more challenges that interest the business society. Mrs. Wenzel, again, will tell you how she intends to pursue her mandate as CDDH rapporteur in the future. Mr. Martin Rood, who is the chairperson of the CDDH drafting committee on traffic for the purpose of labor exploitation, will tell you also about the ongoing work of this structure. And the human rights responsibilities of business enterprises are also an important aspect of the work of the CDDH drafting group on human rights and the environment, a topic again that you just mentioned, Minister Della Vedova, a drafting group which is preparing now a new Committee of Ministers recommendation. So today's event will be an important collaboration, and I'm very grateful again to the Italian authorities, an important collaboration between the Council of Europe and the Italian authorities on a theme of strong common interest, but also a valuable opportunity for us to discuss this theme with other international organizations. And I would like to thank the representatives of the United Nations, the EU, the Fundamental Rights Agency, but also the OECD and the ILO that are with us this afternoon. So a discussion with other international organizations, I'm sure we have a lot to hear from them, but also national experts, trade unions, researchers, and of course, businesses, enterprises themselves. And I was particularly glad to see that among the speakers in the second part of the workshop, there will be at least 1 or 2 representatives of the business, and it's good to have them with us. With that, Mr. Petri, thank you very much again for your very kind invitation. I wish you all the best for the workshop.
Thank you so much, Director Poirel, for your words, and for the engagement of the Council of Europe on this issue that is so fundamental. As we all know now, we will have a first session. The title is Future Perspectives on Business and Human Rights. It's a debate within international organizations representative on the vision on business human rights. As already said by Director Poirel, we are very pleased to have the all most important international organization representative that they deal in different ways with this important issue of business human rights. So thank you again for everybody. I will introduce them slowly, while I will give them the floor. We will start with the Council of Europe. Mrs. Nicola Wenzel, she's the rapporteur on business human rights of the Council of Europe Steering Committee on Human Rights, and Mr. Morten Rood, that is the drafting committee on trafficking for the purpose of labor exploitation. So already, as Mr. Director Poirel said, we will have the vision of Council of Europe on these 2 very, very important aspects. So I think, Mrs. Wenzel, the floor is yours. Thank you again to be with us.
Thank you, Mr. Petri, for the kind words of introduction, and to the Italian Presidency and the Council of Europe for organizing this timely event. It is a great pleasure for me to be here, and looking at the impressive list of my co-speakers, a real honor to participate in this panel. Let me briefly present myself. My name is Nicola Wenze. I represent Germany at the Council of Europe Steering Committee on Human Rights. And human rights and business are part of the issues I work with at the German Federal Ministry of Justice. I was involved in the drafting of our national legislation on due diligence in supply chain, and currently work on the EU due diligence initiative, and also follow the treaty process at UN level. But today I am not representing Germany. I am here as rapporteur on human rights and business of the Council of Europe Steering Committee on Human Rights, and I will focus on the Council of Europe activities in the area of human rights and business. In my presentation, I will proceed as follows. I will start by briefly outlining the Council of Europe's regulatory framework on human rights and business. And then my main topic will be the question, where will the Council of Europe go from there? And I will provide tentative answers in 3 concepts or slogans, as I want to call them. So let's start by having a look at the Council of Europe's regulatory framework on human rights and business. And I will be very brief because this panel is about the future, not the present. So the main instrument of the Council of Europe is Recommendation 3 of 2016 on human rights and business. It was adopted in 2016 and constitutes the cornerstone of Council of Europe activity on human rights and business. For those not familiar with the Council of Europe terminology, I'd just like to remind you that the recommendation is a soft law instrument that is adopted by the Committee of Ministers and contains non-binding recommendations to member states. So our recommendation on human rights and business is strongly based on the United Nations guiding principles on business and human rights, but in certain point goes beyond these principles, gives more detailed prescriptions on what member states shall do. So first of all member states are called upon to effectively implement the United Nations guiding principles. And in particular, they are called upon to adopt national action plans on business and human rights. The recommendation then follows the 3-pillar approach of the UNGP. It sets out the state's duty to protect and state action to enable corporate responsibility to respect human rights. And thirdly, focuses on access to remedy. And this section on access to remedy is very interesting because it is much more detailed than the UNGP. It provides very detailed recommendations on civil liability for business-related human rights abuses, on criminal liability, and also administrative remedies. And these are all the points that are currently being discussed in all efforts, be it at national, EU, or UN level, to develop binding instruments on corporate due diligence obligations. So these are the substantive obligations contained in the instrument in a nutshell. The recommendation also creates, and that could be interesting, a shared information system, the online platform for human rights and business. And we will have a presentation on this concept later on. So I'm not going to go into that point. So the recommendation was adopted in 2016. As I said, that's already been some time ago, and its implementation was reviewed the last years. And this review was also the kickoff for a longer and still ongoing process of reflection within the Council of Europe and also among member states about the future. Where do we go from here? And as I said, I will try to provide tentative answers based on the discussions we had in the steering committee. And I will do that through 3 slogans that will guide Council of Europe activity in their area of human rights and business in the future. So my first concept or slogan is human rights first. Some of you might have noticed that I always use the terms human rights and business to describe the topic that brings us together here today. Human rights and business, that's the way we speak in the Council of Europe, not the other way around, business and human rights, as is common in most other international and regional fora. This is not a coincidence. It is a deliberate choice because the Council of Europe is a human rights organization. Human rights are the Council of Europe's DNA. So while there are organizations that approach our topic more from the business side because of their mandate, the Council of Europe evidently comes from the other side. And I'm not trying to say that one side is good and the other bad. On the contrary, we need both sides. We need the business perspective and we need the human rights perspective, and we need the business expertise and the human rights expertise. I just want to make clear where the Council of Europe comes from. Its focus are the victims of human rights abuses, not the perpetrators. So the Council of Europe is on the human rights side, and in this field brings a huge expertise and know-how. And my firm belief is that this is the added value that the Council of Europe can bring to the discussion on human rights and business. So when we think about what can the Council of Europe do in the future, it is essential, in my view, to creatively how we can best make use of this key competence of the Council of Europe. And one way has already been discussed by the steering committee in our implementation review process. The Council of Europe will consider further work on how to ensure that victims of human rights abuses have access to effective remedies. Because bringing justice to victims of human rights abuses is one of the core competences of the Council of Europe. And I'm certain it will be worthwhile to further pursue that path. So that was my first slogan, human rights first. My second slogan is not really a slogan, I have to admit, but more of a concept that should be familiar to all of you, the concept of mainstreaming. We should mainstream business and human rights. That means we should adopt and integrate a human rights and business perspective in the Council of Europe's different fields of activity. Our discussions in the steering committee have shown that it is immensely fruitful to look at other human rights issues through the lens of human rights and business. And many, if we look closely, many of the current hot topics in the area of human rights have a business component. If we adopt a human rights and business approach when looking at them, we might understand the problem better. We might also see new or additional ways of dealing with the problem. Perhaps we can build on the structures and network of the human rights and business domain in the other context. Linking separate discourses is enlightening. And by linking, I do not only mean drawing a substantive link, I also mean putting together two separate communities of experts. And it is surprising to see what a pool of creativity such meetings are. The Council of Europe has started going down that path. The regulation on the trade in tools of torture has a human rights and business component, for example. Because setting up a trading control system means, in fact, affirming the responsibility of companies to take into account the human rights implications of their business activities and to do no harm. This, in the end, is nothing else than the corporate responsibility to respect we know so well from the UNGP. Now, the recommendation on the trade in tools of torture that the Council of Europe recently adopted acknowledges that links explicitly on a procedural level by providing that member states should use the Council of Europe online platform for human rights and business for information exchange and the sharing of best practices. Another example, the right to a healthy environment that has recently been recognized by the UN Human Rights Council, and that is being discussed in many fora, including the Council of Europe. Well, this topic is also linked with the discussion on human rights and business, because companies contribute to a major extent to environmental pollution, loss of biodiversity, and climate change. A human rights and business perspective might open doors here as well. And that is the reason why last April, the Council of Europe organized a workshop on human rights and business, a framework for addressing environmental protection challenges. And this workshop brought together experts from the human rights area, from environmental law, and also experts from the business and human rights community. And the instrument that was already mentioned by Mr. Poirel at the beginning on human rights and the environment that we're currently discussing within the Steering Committee on Human Rights will most likely also make the linkage. These are first steps, but very promising first steps. That's why I think that my second slogan, mainstreaming human rights and business, should guide Council of Europe action in the future. Now coming to the last, my third slogan, let's do it together. If you look at our panel today, you will see that the 5 of us represent 5 different organizations that in one way or the other work in the area of human rights and business. The UN, the EU, OECD, and ILO. There are many others. Some organizations are more business-oriented, others more human rights-oriented. Some are regional, some are international, some are supranational. A plurality of actors means great potential. And in my view, in the area of human rights and business, the interplay between different organizations and different standards has been a success story. In order for that to remain so, we might consider even closer cooperation in the future. I might be too idealistic, but I would wish for a holistic approach, a common reflection on the unique capabilities of the different organizations and the ways they can best contribute to furthering the discussion on human rights and business. In the long run, we should aim at building an integrated system in which the different actors and their standards build on each other and complement each other. A good way to start would be for each organization, when taking specific action, reflect in what way other organizations could contribute and complement their action. This is not meant as a critique of the status quo, because there already are very good examples and promising examples. Let me just mention the outstanding cooperation and outreach efforts between the EU, the UN, and the Council of Europe in particular in the area of the trade in tools of torture. So it is not meant as a critique, but rather as an encouragement to do even more in the future. To conclude, I have put forward in my intervention 3 slogans: human rights first, mainstreaming human rights and business, let's do it together. I have shown that these principles are already inherent in the Council of Europe's work on human rights and business. And I think that they constitute a good roadmap for everything that is to follow. Thank you.
Mrs. Wenzel, thank you so much. Of course, from now onwards, this workshop will be called International Workshop on Human Rights and Business. So, because I think that what you said is very, very interesting. And of course, we here are all believers in the importance of human rights. So thank you so much. I will give now the floor to Mr. Morten Rood, always of Council of Europe. Mr. Rood, please, the floor is yours.
Thank you, Mr. Petri, for giving me the floor, and thanks to the Italian authorities for hosting this very important workshop. My colleague from the Steering Committee for Human Rights, Ms. Nicola Wenzel, has given you the overview of that Steering Committee's work on business and human rights. And later during this session, we shall also have a presentation from Mr. Tigran Karapetyan, on the online platform for human rights and business. I shall, in this short intervention, present some information on another ongoing work under the CDDH relating to the same subject, namely the work on a recommendation on combating trafficking for the purpose of labor exploitation. Trafficking in human beings have for a long time been a plague and a concern for civilized nations. The public awareness has perhaps mainly been on trafficking of women for sexual exploitation, but trafficking occurs also for other purposes. It might be said that what we today call trafficking is a direct continuation of the former days slavery, sometimes even described as modern slavery, although it is hard to see what is modern about it. The Council of Europe has for many years been engaged in the fight against trafficking. The organization adopted in 2005 a convention on action against trafficking in human beings. And when that convention entered into force in 2008, a special monitoring body, the Group of Experts on Action Against Trafficking in Human Beings, called GRETA, was set up. The group follows closely the situation in all member states and gives detailed advice to all of them based on visits and reports submitted. In recent years, there has been increased awareness on trafficking for the purpose of labor exploitation. In 2020, the Committee of Ministers of the Council of Europe decided that there was a need for strengthened attention to this problem, and it was decided to elaborate a recommendation to member states on how to fight this criminal activity. People in need and distress are migrating, many of them to Europe, and they are vulnerable for exploitation. The situation we now see connected to the unlawful and horrendous attack on Ukraine forces millions to flee from their homes and to seek refuge in other countries. Civilians fleeing for safety are also indeed concerned about how to survive in a foreign country, and they are easy targets for people with ill intentions. The link to human rights and business is obvious. There is a clear need for awareness also for legitimate commercial activities and for the general public. Businesses competing for contracts or selling products to the general public will of course always be forced to press prices in order to make their services competitive. Such serious businesses must, however, be aware of the situation of their subcontractors and should be responsible for avoiding violations among them. The task of drafting the recommendation was given to a special committee of the Council of Europe, drawing on resources from several branches of the organization's activities. Much of the preparation was done by GRETA and its secretariat, based on the experience of this body. But GRETA is a monitoring body. It was considered necessary to include expertise and experience from other fields, such as criminal law, human rights, and social rights, and experts in standard setting to supplement the expertise of GRETA. So the drafting committee was set up under the auspices of the steering committee on human rights, with members appointed also from GRETA, from the steering committee for criminal law and social rights committee, in addition to 5 experts appointed by the Secretary General of the Council of Europe. In addition, all member states of the Council of Europe are free and are invited and encouraged to send experts to the meetings of the committee, and the meetings are also open to participation from a number of NGOs which actively then have participated. The committee shall report to the steering committee on human rights, who shall provisionally adopt the recommendation and submit it to the Committee of Ministers for final adoption. A deadline was set to 1st of July this year. As outgoing chairperson of the steering committee, I was asked to chair this subcommittee, a request I was very proud to accept. So far, the committee has had 3 meetings, and a 4th and final meeting will take place late in April. When I accepted the task, I was not prepared to the fact that due to the COVID situation, all meetings have been on the web. I could speak for a long time about the challenges of chairing a committee of about 50 strongly engaged participants, on the task of drafting a detailed legal text as a recommendation, even if it's a soft law text. If asked in advance, I would claim that it would be strictly impossible to do it in such a short time. Drafting a legal text with a lot of engaged experts when you cannot physically meet the persons engaged is very, very cumbersome. But thanks to the very positive attitude of all members of the committee, I now feel quite sure that we shall be able to present a draft for the steering committee in time. This is, of course, also due to fantastic work done by the Secretariat of the Council of Europe, both the Greta Secretariat and the Special Secretariat appointed to serve this committee. As the work is not yet finalized, it would be premature for me to present the detailed outcome, but I can give you an overview of the structure. We are not asked to draft a convention. As I mentioned, the Council of Europe already have a convention. The recommendation, being what we call a soft law instrument, shall give guidance and ideas to member states and set standards for their engagement to fight the trafficking in human beings for labor exploitation. It shall have a holistic approach covering various aspects of what should be member states' measures in this field. The first part of the recommendation will deal with prevention and will especially underline the role of labor inspectors and their cooperation with other official branches, such as police and prosecution, as well as immigration. Labor market regulation is an important tool, and also included here the right to visit and inspect workplaces, especially those not open to the general public. Serious violations can take place in private homes and private settings, or for instance in the agricultural section. Regulations on minimum wages must of course also apply to migrant workers. But the challenge in this field is that many victims of trafficking are not seen as employed persons, but are bogusly declared as self-employees. Forced begging is another challenge in this respect. The second part of the recommendation deals with protection, both identification of the victims and assistance and protection, and the right to compensation. Compensation should, of course, primarily come from the offenders, but they will not always be available to pay compensation. So there's a need of state involvement and state support here too. There will further be a section on prosecution, and finally a section on action to enable corporate responsibility and enforce corporate liability. I shall conclude by saying that our task is not the setup, as I said, of binding rules, but rather to give member states inspiration and ideas, and to indicate standards for the work they are obliged to take in their fight against human trafficking. I close there. Thank you, Mr. Chairman, for giving me the floor.
Thank you so much, Professor Ruud. It was very interesting. Thank you for this very interesting news from the Council of Europe on your work, and all the best. Really, I think that we know that at the end of this session, we will have again an intervention of the Council of Europe, but now we will go to United Nations. We have with us Professor Surya Deva of the Working Group on Business and Human Rights, or Human Rights and Business. We are very happy that Professor Surya is with us. He was with us in person in October when the working group paid a country visit to Italy. It was a very important visit. It helped us to shape also the second National Action Plan. So we are very, very, very happy that Professor Surya is also with us today. Professor Surya, the floor is yours. Thank you again.
Thank you very much, Minister Petri. I hope you can hear me.
Perfectly.
Yeah. So I'm joining this session from Dhaka, in Bangladesh, and I very much hope that this internet supports me in making this presentation. So let's wish that it works fine. At the outset, I would like to thank the organizers for the invitation and also congratulate the Italian presidency for the leadership they're showing in the field of business and human rights. I will agree personally with Nicola in terms of the framing and calling it human rights and business, and have written about it many, many years ago that we should not be calling it BHR, rather we should be calling it HRB. But for the purpose of convenience, I will stick with BHR in today's context. And I think that leadership shown by Italy was also evident in inviting the working group for the country visit, because not all countries are willing to do that. So we are very much appreciative of that leadership shown by Italy, not merely words, but action. So the focus of this workshop or this particular session is the future of business and human rights. But the future is built on the present and the past. So I would like to start with the present, and I will make 3 points about the present. And then in terms of the future, I will make 6 things or 6 suggestions or the points which may be of relevance. And some of these points may connect with what was mentioned by Nicola, and perhaps the colleagues who will speak after me from ILO, OECD may build on some of these points, or they could be some divergence and we can discuss about those elements. Let me start with the present. I think it is fair to say that UN guiding principles have provided a common currency in the business and human rights field. The tripartite framework of protect, respect, and remedy is crucial because it highlights the differentiated but complementary role of both states and businesses. The tool of human rights due diligence, which was there earlier also before the guiding principles, but it was not really framed as such as 4-step dynamic process, is again a significant contribution of UN guiding principles. So I think this is not an ordinary achievement in my view, that in a space of about 10, 11 years, the UN guiding principles have become the lingua franca in the field of business and human rights, a field which has been quite divisive and continues to be so when it comes to the binding rules and all that. So I think this is a very significant achievement in my view. The second is that when we talk about UN guiding principles, and if you look at the framing of pillars, the predominant focus is on states or businesses. For instance, civil society are not given a prominent space in the 3 pillars of the UN guiding principles. The role of other actors, whether these are NHRIs, these are trade unions, or role of international organizations or NCPs is also incidental, I would say. But I think what we can learn from the dissemination and implementation of UN guiding principles is that in practice, the adoption of the UN guiding principles and their mantras have gone beyond states and businesses. So from academia to lawyers, to trade unions, to investors, to sports associations, to international organizations, everyone is now talking about the language of UN guiding principles. This is, in my view, the second significant element of where we are in terms of the present state of affairs. The third issue that I would like to highlight, which is not perhaps so positive as my first 2 points, is that I see that the political will on the part of the states is very limited still. And I can say that because of my extensive bilateral engagements, visits all over the world in all 6 continents, I can say this with confidence that across the world, governments are talking about UN guiding principles and their implementation. When it comes to actual implementation, there are significant hesitations. So the political will is there in making a political commitment to implement. But the actual implementation, there is significant deficit in the political will. And I think that explains, in my view, why the European Commission had to come up with the mandatory due diligence process, why the treaty process started, because the gaps are very, very significant in the on paper promises and in practice implementation. And I give one concrete example of this that I hear often all the time, including in Bangladesh, where I am. There are serious concerns expressed about a potential conflict between economic development and respecting human rights and the environment and climate change. This is very real, I can tell you. Let us not pretend about it. It's a very real conflict. When I visited Italy, we saw that conflict as well in relation to certain case studies. Because the question is, should 10,000 people who are working in a particular steel plant, should they be fired if the plant is closed? Or should we protect, because if we protect the environment, the plant may have to be closed. And that means 10,000 people will lose their jobs and livelihood. So this is a serious conflict or contradiction. How do we manage it? This is a real issue I think we need to grapple with, and I think many countries and many companies are facing that issue, in my view. So this is my reflection about the present. Where should we be going? What should be the future of business and human rights? And I would like to mention here 6 elements for your consideration. First is the binding rules. I'm not suggesting that voluntary rules are not needed, because binding rules at the national level, at the international level, or at the regional level, they can never be ambitious enough. And I think that is where the role of soft standards will always be there. But what is crucial is that these are the binding rules, not merely on paper. These are binding rules also in practice. Because let us say international treaties are binding on paper, but in practice, many states don't really implement those treaties even after ratification. So what is crucial is that we are talking about binding rules, not merely on paper, but binding rules in practice. And there are other elements of this bindingness which we need to consider. Let us say about the scope of the application. Now, the proposed European Commission directive, if I remember correctly, the category 1 companies, we're talking about around 9,000 to 10,000 companies. But European Union companies are many more than 10,000. So what about other companies? What will be the dynamics? I think this is a key question that we need to consider. So what will be the interface of binding rules with the soft standards? I think we need to pay greater attention to that. In my personal view, and I have written about it, my suggestion is that in future, we should be encouraging all businesses to conduct human rights due diligence. And I'm underlining the word encouraging it. And then we need to mandate certain businesses. And those certain could be big sizes in certain situations, or these could be all businesses because they're operating in a particular context. I will not have time to explain, but I'm happy to answer if there are any questions. So I think that is the dynamics which is very crucial in future. So how the interface between the binding rules at the national, regional, international level and the soft standards like the OECD guidelines and the UN guiding principles, the Yemeni Declaration, how will they sit together? I think we are not paying enough attention to that dynamics and interface in my view yet. Second, mandatory human rights due diligence, despite all the optimism around it at this point of time, is not going to address many issues. I can predict it, and we can have a workshop in 2030 on this, Minister Patry. Why I am saying it? Because 10 years back, as an academic, I argued that the pillar 2, the voluntary aspect of it, will fail. And now everyone is talking about that without the mandatory thing, pillar 2 doesn't really work alone. And I'm going to predict now, let us see what happens. The mandatory due diligence alone will not fix everything. And I think that is why it will not fix everything. I will give one example. Because it does not address imbalances of power. the imbalances of power between corporations and the affected communities. And I think that is where the role of civil society organizations, role of human rights defenders, role of trade unions, role of NHRIs, role of lawyers, role of academia is crucial. How do we utilize these other actors to address this imbalance of power about information, about financial resources, about legal aid? This should be getting more attention rather than all of us just focusing on mandatory human rights due diligence, in my view. My third element for future is that we need to pay greater attention to small and medium-sized enterprises and informal economy. I don't think we are paying enough attention to the largest economic actors, especially in the part where I am living now, in the South Asia, for instance. Let us take South Asia as a case study. But South Asia is not unique. If you look at even Europe, there are many businesses which are part of SMEs. So if we just focus on multinational corporations and their supply chains, that is a good starting point, but that is not the entire BHR landscape. So what are the tools that are needed? What are the incentives that are needed for the SMEs and the informal economy actors? This is going to be a crucial issue going forward, in my view. The fourth is connecting the agendas. Business and human rights is a field, but I think more importantly, in my view, this is a lens. What is not business and human rights? Tell me anything in the world which is not BHR. From the Russian invasion to Ukraine, to the issues about whether we should be sending people in the space for recreation or exploring anything or supplying basic services, artificial intelligence, climate change, you name it. Everything is business and human rights. So what is crucial, and I think that is where I would like to connect it with what Nicola was mentioning. She was talking about mainstreaming. I call it connecting the dots. What is crucial is that the lens of business and human rights has to inform all the agendas, from sustainable development goals to the emerging issues of gig economy, artificial intelligence, to automation and climate change. I think that is very crucial. My fourth and the second last point is that access to remedy should be given more attention. Prevention is never foolproof. It's ideal if we can prevent abuses, but I can tell you prevention will never be foolproof. You need a strong accountability and remediation mechanism, because that also sends a signal to businesses that free riding is not beneficial for them. And I think that is where we need to create robust judicial and non-judicial mechanisms at the national level, but more importantly, I would highlight at the regional and international level, because there will always be cases where you cannot seek remedies at the national level. This is unfortunate, but that it will always be the case. And of course, we're talking about transnational business operations. So we need those systems which are effective at the regional as well as at the international level. And my last point is about, which is more systemic issues. Perhaps we need a new economic model. Perhaps we need a new governance model. Perhaps we need new business model. We need to be asking this question that whether this idea of multinationals with long supply chains is sustainable, or we need to go back to more local and smaller business models. We need to be asking this question that what to do when a country like Russia attacks in Ukraine. What is the responsibility of those situations? What to do in a country which does not allow independent trade unions? These are real questions. We can pretend and say that every country is supportive of UN guiding principles and OECD guidelines and the ILO declaration. But the sad reality is we are struggling. The poverty is increasing. The child labor in the pandemic has increased for the first time in the history. It's very likely that we will not be achieving sustainable development goals. So we need to have serious discussion rather than living in this illusion of making progress. that we need to ask these hard questions to challenge the economic model that we are having and challenge the governance model and the business models that we're living. So I will stop with that. Thank you very much once again for the invitation, and I look forward to listening to my fellow panelists. Thank you.
Thank you, Professor Surya Deva. It was so interesting. Thank you again for underlining our commitments. As Italy, we were very, very pleased that you came and the working group came to Italy last year. So it was a very important occasion to grow as person, as community involved in business, human rights in business. And thank you for what you said about the future. Very interesting remarks. Now we have the European Union Fundamental Rights Agency. We have Dr. Patricia Podoginska. I don't know if I pronounced very correctly your name, but you are welcome. We are very happy that you are with us. We believe a lot in the work of the Fundamental Rights Agency. And please, the floor is yours.
Thank you very much. Thank you very much for inviting us to this very interesting event. And I will not spend a lot of time for introductions. So I represent the European Union Agency for Fundamental Rights. And we have started a couple of years ago our work on business and human rights, or human rights and business. And I would really underline the points that were raised by Professor Deva, that the major points is that the attention to access to remedy is very important, because the best laws are only as best as they are enforced correctly. And what we actually, in our latest research that we have conducted in 2019 and 2020, that combined desk research and fieldwork and interviews with lawyers and experts, experience in litigation against corporations, that the key, and I cannot agree more, the key words and the key obstacles is the imbalance of power. Our major conclusions were that the existing relevant instruments, even if sometimes in some cases, like in the branch of consumer protection, are almost perfect on paper, they do not take sufficient account of the reality and complexity of disputes involving big corporations. And in most cases, these are multinational entities with complex structures and networks of subsidiaries and supply chains. Already, we have heard today that the United Nations and Council of Europe instruments point also to the need of judicial and non-judicial mechanisms to ensure effective access to remedy for victims of abuse of human rights that are related to business activity. However, our findings also indicated that non-judicial remedies remain largely unknown or lack sufficient effectiveness, or their potential is not fully used. Courts therefore remain the main avenue for accessing justice in business-related human rights abuses. However, we tried to, when our research aimed to examine the effectiveness of this avenue, it turned out that there is a lack of specific procedures addressing such abuses, and depending on the nature of the abuse, either civil, criminal, or administrative proceedings may be available, but always the business-related human rights abuse are atypical, and this face numerous procedural obstacles. In all countries that our research covered, interviews pointed to practical, procedural, and financial barriers. So as a conclusions of our research, we pointed to a couple of points and quite easy, maybe not revolutionary, but ways of improving the situation that would not require drastic change, but really small points and small, easy to achieve amendments of procedure that would immensely improve the situation of victims and their access to justice. One of the points is shifting the burden of proof and obliging companies to disclose the information that victims need to establish a claim in order to address, that would address major barrier that we have identified, and also is the major source of inequalities between victims and business. Proving wrongdoing or liability is a major problem. Depending on the legal system that victims choose to use, there are various types of proof that are required, including a requirement to establish a company's liability, as well as various levels of causality, the link between the activity and the damage. We have seen the burden of proof in most legal systems even to substantiate the claim. If individuals are required that they are directly affected by the actions of a business. That's also another issue regarding the complexity of the structure, whether it was whether there is a liability of maybe a subsidiary or affiliated firms, and in cross-border cases it's even more difficult. So the disclosure, different obligations regarding burden of proof should be improved. And we see there are other branches of law, like non-discrimination, labor laws, where this burden of proof is shifted, and there are different ways to do that we analyze in our report. There's no time to go in more details. Another issue is the accessibility and effectiveness of collective redress or representative action procedures. They should be extended to cover all kinds of business-related or environmental-related abuses. And that would make a more realistic chance for financial compensation. There's already a European EU directive that will soon, the deadline for implementation, there's still a couple of months for member states to implement. That is a potential, there's a big potential of improvement of the situation, but of course it still leaves member states some margin of flexibility how they're going to do that. And what we have underlined is this efficient collective redress must allow not only to establish liability, but also damages in one proceeding, so that not to prolong the procedure and not to increase the cost incurred by the victims. Financial, legally supporting civil society organizations, and also court alternatives like national human institutions, ombuds institutions, consumer organizations is crucial. We have seen that in our research, work of civil society in supporting victims is crucial. Particularly, there is not possible for an individual to lodge a claim, and they support the victims not only financially but also with their knowledge and legal assistance. However, the cost and the complexity of the cases are that such enormous that even for societies, for organizations, that becomes more and more financial burden, and therefore they may soon be incapable, or they may not be willing to take on a case for that reason. We also seen that there is a big potential of certain ombuds institutions, and we have recommended that they competence as well as resources are strengthened. There are also ways of big room of improvement as regards legal aid rules that should be reviewed, so victims can afford to challenge business, and the cost of proceedings do not constitute a deterrent for victims as well as for NGOs who are dealing with strategic litigations. Experts have highlighted that legal systems currently are inadequate in light of the overall cost that has to be incurred, that legal aid often covers only legal advice costs, but not all the costs that are involved in bringing a claim. Also, in order to substantiate the claim. there are a lot of costs that are go beyond court fees that may not be very high in some countries, but I mean the court fees might not be high, but the other costs related, such as the court of experts' opinions, are very high, and also they are high for victims even if they win the case. Unfortunately, very often for different procedural reasons, victims do not even succeed the court proceedings. Even more challenges can be identified in cross-border cases where there's additional issues of applicable law or establishing jurisdiction of an EU country if necessary, finding witnesses, and also there's language barriers. Finally, and again, I fully agree with what has been said by Professor Deva, horizontal human rights due diligence that is also currently already proposed on the EU level, and there is a potential, but our research also proves that this potential is limited. It's not only the question of the final scope of the due diligence, whether how many companies and how big companies would be covered by that. But also it will depend how public and what would be the scope of reporting that arguably is one of the important aspects of due diligence that would contribute to directly to access to remedy. And that ought to be also useful in terms of identifying links between company and subsidiaries, but again, it has to be seen how what will be the final scope, and it will not solve all the issues and all the problems of procedure that are currently existing and that will not be addressed by due diligence alone. I would think my time is coming to an end, so I would stop there. Just one more sentence regarding the future. We are continuing our research in this area. We are now starting a new project that will focus on exploring the role of consumers to ensure more environmental protection as well, but it kind of also overlaps broadly human rights abuses and how encourage or enforce certain sustainable behavior of business entities on different level of the product life. And I will stop there in case of questions available.
Thank you so much.
Thank you very much.
Thank you to you. It's always a pleasure to do work with you, with the FRA, with the Fundamental Rights Agency. I was, of course, in Vienna 3 weeks ago. I met with the director, but that was in my other hat of special envoy for human rights of LGBTQ+ person. But really, it's always a pleasure to work with the Fundamental Rights Agency. Thank you for your insight. Now we go to another important, very important organization. We have with us Professor Alan Jorgensen, head of the OECD Center for Responsible Business Conduct. We are particularly happy to have with us the OECD, and we give the floor to Professor Jorgensen. I hope you are online.
I am indeed. Thank you very much, Minister Petri. I hope you can also hear me. Good afternoon.
Yes, we can hear you. Welcome.
Thank you. Good afternoon, Excellencies and dear colleagues. On behalf of the OECD, let me begin by thanking the Italian Presidency of the Council of Europe for convening this workshop today. I also send greetings from the chair of the OECD Working Party on Responsible Business Conduct, Professor Christine Kaufmann, who unfortunately is prevented from attending today. I'll begin by saying that the long-standing work of the OECD on responsible business conduct, of course, is rooted in the OECD guidelines for multinational enterprises. This is a comprehensive instrument covering all aspects of responsible business, including business impacts on people, but also importantly on the environment and on the broader society. The guidelines are adhered to by 50 governments, going well beyond the OECD membership, which is 38 governments. And the adhering countries to the OECD guidelines come from all the world regions. And the guidelines in turn are applied by private actors throughout global supply chains. The guidelines also include a national implementation mechanism, which is unique. These are the national contact points that exist in all of the 50 countries that adhere to the guidelines. And they are mandated to promote responsible business conduct and also to facilitate access to remedy in instances where the guidelines are not being upheld. And I'm pleased to say that we'll be hearing later from Ms. Benedetta Francesconi, who is chief in charge of Italy's national contact point for responsible business conduct. The OECD is currently undertaking a stock-taking exercise to ensure that the OECD guidelines for multinational enterprises and their implementation remain fit for purpose. And in that context, I'm particularly pleased, Minister, to contribute some reflections by the OECD on future perspectives related to business and human rights. Let me start by saying that the future, of course, is not what it used to be. This is a phrase that we normally use, but it's particularly important in the years and months and weeks that we are living through at the moment. In that regard, I also want to start on the good news, and that is that the global consensus on business and human rights and on responsible business conduct that has been carefully and painstakingly built during the past decade or two probably represent one of the most important contributions to the rules-based multilateral system that we have seen for a number of decades. And it's certainly a consensus that we must protect, that must be preserved and deepened, and which is needed now more than ever. The members of the OECD are very much united in a vision to build strong, sustainable and inclusive societies with open markets that are based on democracy, rule of law, human rights, and environmental sustainability. And it goes without saying that none of this can, of course, be achieved without responsible business conduct, without the norms that we're discussing today on business and human rights. Let me give 3 examples of key challenges, key agendas that the business and human rights principles, the responsible business conduct principles, will have to be important in the future in order to succeed. First, of course, the climate crisis. At the recent COP26, we saw a surge of corporate and investor commitments to net zero emissions by 2050 in line with science-based pathways. This is very significant because the goals of the Paris Agreement can, of course, not be reached without the leadership of the private sector and the investor community. In turn, policymakers, including in the EU, but also elsewhere, are increasingly encouraging or even requiring corporates to adopt transition plans aligned with the goals of the Paris Agreement. We have now over 1/5 of the world's 2,000 largest public companies that have made some sort of net zero commitment to carbon neutrality by no later than mid-century. It's also the case that many of these commitments are difficult to compare. Greater clarity is needed in order to ensure that these pledges are credible and that they will be efficient in line with climate science and the need for a just transition out of and into new technologies. With the emphasis on risk-based due diligence on environmental impacts, the OECD guidelines for multinational enterprises can help promote this alignment and accountability when it comes to corporate net zero commitments. The second global trend that I want to mention is the shrinking civic space that we're seeing across the world. Human rights, rule of law, and their associated institutions are increasingly coming under pressure at a time where we need them the most. Freedom House last year was able to report the 15th consecutive year of decline in global freedom. In 2020, according to Global Witness, there were 227 land and environmental activists that were killed defending their land and the environment. Similarly, the share of the global population living in liberal democracies has stagnated in recent decades. And for companies, this means that heightened due diligence is increasingly needed in relation to vulnerability of stakeholders and meaningful stakeholder engagement when operating in high-risk environments. So the governance gap that the UN Guiding Principles on Business and Human Rights were supposed to address is very much present for companies and very much remains a challenge also in terms of business and human rights. Third, I want to talk about the importance and current pressures when it comes to open, sustainable, and resilient supply chains. Today, we have about 70% of international trade involving international value chains, whereby services, raw materials, parts, or components cross borders often numerous times before they are incorporated into a final product and shipped to consumers all over the world. Without global value chains, the truth is that our societies and the people in them would be poorer, consumers and workers alike. Open trade has contributed more than perhaps any other force to the improvement of people's lives and livelihoods during the past 3 to 4 decades. Millions have been able to lift themselves out of poverty, and growing prosperity has also allowed governments to improve provision of basic services. We saw also, unfortunately, that the COVID-19 pandemic and the disruption that it caused in global supply chains have rolled back some of this progress. And so for the first time in many years, we have seen increases in extreme poverty. We're seeing increases in the prevalence of child labor. This is the significance of prosperity and open trade, well-functioning supply chains to the well-being and livelihoods of people, and in terms also to human rights. And it has underscored the importance of open, sustainable, and resilient supply chains, and thereby in turn also responsible business conduct as an enabler of trust, sustainability, and resilience in the supply chain. Now, the war in Ukraine has brought this into an even starker perspective. The OECD, of course, has condemned in the strongest possible terms the large-scale aggression by Russia against Ukraine. The most important consequence of the war, of course, is the lives lost and the humanitarian crisis associated with the numbers of besieged and displaced people. From an economic perspective, the war in Ukraine has created a new shock for the world economy at a time when the economy was just starting to recover from some of the challenges that we were seeing during the pandemic. The war has already resulted in sizable economic and financial shocks, particularly in energy, food, and commodity markets. This could have sustained reduced global GDP growth by more than 1 percentage point in the first year. And it could also push up global consumer price inflation by approximately 2.5 percentage points, something which low-income groups would be likely to bear the bulk of the suffering for. The war, therefore, has amplified the questions that we were already asking ourselves about the resilience of global supply chains in critical areas that have, in turn, deep consequences for people and for the climate. And in all this, the choices made by companies in response to the war are going to partly determine some of the effects and how they will impact on people in Ukraine, in Russia, and throughout the global economy. Foreign businesses operating across all sectors have taken decisions to disengage from the Russian market with exceptional speed, with rationales that straddle ethics, logistics, legal, reputational risks. As businesses are confronting these choices by the war, posed by the war, universally agreed principles on business and human rights and responsible business conduct can offer important guidance. In their simplest form, these principles imply a 3-part test. Companies must comply with the law, they must respect human rights, and contribute to sustainable development. In summary, there is a lot at stake if we look ahead for business and human rights. The climate crisis, the threat to democratic institutions, and to the sustainability and resilience of global supply chains. These are shared challenges that can only be met with shared standards. The OECD guidelines for multinational enterprises, the UN Guiding Principles on Business and Human Rights, and the ILO Tripartite Declaration provide a coherent and aligned framework for meeting some of these challenges through true multilateral collaboration. In a recent joint letter to President von der Leyen, the heads of these three institutions welcomed the efforts by the European Commission to make use of this framework in policy in the context of the recent European Commission proposal for corporate sustainable due diligence. This provides a significant opportunity to scale up uptake of responsible business conduct practices. Alignment with established standards is necessary to ensure their effectiveness while reducing also cost and complexity for business. And using common standards will increase the chances of global coherence across regions and countries, whether through mandatory or voluntary frameworks. So through its work on responsible business conduct, the OECD stands ready to facilitate multilateral and inclusive cooperation to address these common challenges based on shared standards. Minister, I thank you and look forward to the continued discussion.
But thank you to you. First thing, it was really a pleasure to have the OECD with us, to have you, Professor Jorgensen, and thank you for all that you said also about the terrible war, the aggression against Ukraine. It's really very, very important what you said, and it's very important this overview that you gave from your perspective. So thank you again. And now we go to the International Labour Organization. So really we are also extremely happy and pleased to have with us Mrs. Gita Rolands, Multinational Enterprise and Enterprise Engagement Unit. So Ms. Gita Rolands, the floor is yours. Thank you again to be with us today.
Yes, thank you very much, Minister Petri. I hope you can hear me.
Perfectly. Thank you.
Okay, thank you very much. So I would like to start by thanking you and the Italian presidency of the Council of Europe for inviting us, the ILO, and to share perspectives in this panel discussion on future perspectives on business and human rights. It is a pleasure for me to participate in this very timely discussion, of course, on business and human rights, as the working group on business and human rights presented only a few months ago its roadmap for the next decade of the UN Guiding Principles, looking at the achievements of the past 10 years and important remaining challenges. And I was very pleased to hear Professor Deva already highlighting a number of these challenges in his intervention earlier on the panel. I would like to build on what previous speakers have already shared in relation to the broad human rights, business and human rights agenda, and how also the ILO contributes to this agenda. Now, it has already been said by a number of other speakers, but the protection and respect for labor rights are obviously a central component of the business and human rights agenda. This is recognized in the UNGPs themselves, especially in the Pillar 2, that lists among the human rights that businesses should respect the ILO fundamental principles and rights at work. Labor rights are human rights, and many of these rights have been codified in international labor standards, conventions, and recommendations that, of course, in the case of conventions, all the ILO member states are invited to ratify and then effectively implement in law and practice, including through labor law, well-functioning labor administration, and labor inspection. And that is, of course, very much of what the ILO does, including through its supervisory mechanism in terms of all of the 187 ILO member states. The ILO also has its own instruments in the area of business and human rights, or human rights and decent work, as we sometimes also call it, namely the Declaration on Fundamental Principles and Rights at Work, as well as the Tripartite Declaration of Principles concerning multinational enterprises and social policy, the M&E declaration, which was already also mentioned by other speakers. Now, this last instrument, so the M&E declaration, was last updated in 2017 and includes references to the UN Guiding Principles on Business and Human Rights, as well as to the 2030 Agenda on Sustainable Development, because there we really see how this whole agenda comes together and what it is that should guide us in policies to achieving the 2030 Agenda. And together with the UNGPs, the OECD M&E guidelines, the M&E declaration are considered the 3 international global standards on responsible business, with clear recommendations on how business should contribute to the realization of human rights, decent work, the environment, etc. And we see how these standards increasingly are being incorporated in trade and investment agreements, as well as in legislation on due diligence. It was already mentioned before by Alan Jorgensen, how the new EU proposed due diligence legislation builds on these international standards. Reference to these international standards, and more importantly, a close alignment with these standards and the underlying international treaties for any regional and national legislative initiatives, as well as cross-border agreements, is an important contribution to international policy coherence and for creating a global level playing field that everyone is looking for. Now, in relation to the state duty to protect, I would like to go a bit deeper into the national action plans on business and human rights. The interrelationship between international labor standards and the UNGPs, as well as national action plans on business and human rights. Together with the Working Group on Business and Human Rights, the ILO has published in June last year a brief precisely on the interlinkages between international labor standards, the UNGPs, and national action plans. This briefing note is addressed to governments, employers and workers organizations, who all have a critical role to play in the development, adoption, and implementation of such NAPs, especially in identifying synergies and opportunities for enhancing the government's role in the protection of labor rights, as well as enhancing business respect for labor rights in their operations, and increasing access to remedy for victims of corporate human rights abuses. And while producing this briefing, we have seen that an increasing number of NAPs start to include ratification and or better implementation of ILO conventions, and that these commitments go well beyond the ratification of ILO core conventions, but also start to cover ratification, for example, of the Minimum Wage Convention, ratification on the Indigenous Populations Convention, or other ILO conventions that are seen as particularly relevant to address specific business and human rights challenges in the country. We also see that NAPs include the promotion of the ILO Help Desk for Business on national labor standards as part of the guidance and support to business to conduct due diligence and address labor rights infringements in their operations. And a number of NAPs also include the strengthening of industrial relations and strengthening of labor courts as part of the access to remedy pillar. And these are important developments that can only be encouraged in the future and next generation of NAPs to ensure the better protection of human rights of workers and their families in business operations. And we strongly encourage the active engagements of ministries of labor, as well as employers and workers organizations in the formulation, adoption, implementation, and evaluation of such NAPs. Now, it was already addressed before, but I would like to highlight or go in a bit more in detail on the impact of COVID-19 on the world of work, because this crisis has clearly indicated a number of areas that require increased attention in the business and human rights agenda, as this pandemic and measures to contain the pandemic have exacerbated existing deficits in the protection of labor rights. A number of these decent work deficits have already been mentioned, such as the increase in child labor, for the first time an increase in the past 20 years. And that is an issue that will definitely be addressed in next month's 5th Global Child Labor Conference, which will be organized in South Africa. But also the need to focus more on occupational safety and health, the need for increased and inclusive social protection, and accelerated efforts for transitioning from the informal to the formal economy because of the lack of labor rights and human rights protection in the informal economy and the impossibility to secure an income for women and men working in the informal economy, which has led to increased vulnerability and poverty, leading to exploitation such as trafficking and forced labor, as was already touched upon in this workshop. Also the need to refocus on gender equality, as women were impacted very heavily by the pandemic and its accompanying measures because of the sectors where women are predominantly working in, but also because of the increased difficulties in work-life balance for numerous reasons. Also a need to assist sustainable and resilient enterprises and supply chains that contribute to decent work, human rights, and inclusive economic growth. Now, in the ILO, many discussions have already taken place among governments, employers, and workers on how to respond to the challenges the world of work is facing as a result of the transformation of the world of work and the impact of various simultaneous crises, such as the COVID-19 pandemic, as well as the environmental crisis, as was mentioned before. And in 2021, the ILO adopted a global call to action for a human-centered recovery from the COVID-19 crisis that is inclusive, sustainable, and resilient. And this call to action is particularly relevant in the discussion on business and human rights, as it includes a call to provide all workers with adequate protection, reinforcing respect for international labor standards, and promoting their ratification, implementation, and supervision, with particular attention to areas where serious gaps have been revealed by the crisis. And this includes respect for fundamental principles and rights at work, an adequate minimum wage, either statutory or negotiated, maximum limits on working time, and safety and health at work, with particular attention to the ongoing challenges presented by the COVID-19 pandemic. It also calls to redouble efforts to address the increasing fundamental rights violations resulting from the pandemic, with special emphasis on the elimination of child and forced labor. It also calls for a transformative agenda for gender equality, universal social protection, strengthening of social dialogue, and strengthening of occupational safety and health measures, recognizing that safe and healthy working conditions are fundamental to decent work. Now, there are a number of specific initiatives that I could highlight here, but I would like to draw your attention to safe and healthy working conditions and the concrete process currently ongoing in the ILO to include occupational safety and health in the fundamental principles and rights at work, as expressed in the 1998 Declaration on Fundamental Principles and Rights at Work. And in June this year, the 110th International Labour Conference will discuss and decide on the inclusion of safe and healthy working conditions in the ILO's framework of fundamental principles and rights at work through an amendment to the ILO Declaration on Fundamental Principles and Rights at Work, thus adding occupational safety and health to the existing fundamental principles and rights at work, namely freedom of association and collective bargaining, elimination of child labor, elimination of forced labor, and elimination of discrimination in employment and occupation. Now, just looking to the future, and I will finish with that, there is clearly a need for increased collective action, bringing together all actors to address underlying and systemic issues that can be identified through due diligence. And I think that is something Professor Deva already highlighted as well. Due diligence is a very useful process, but systemic and underlying issues cannot be resolved by one company alone. So collective action that clearly recognize the different actors having different roles and responsibilities, but bringing them together to bring about a change and using different leverage points, that is what we need to look at, and identifying these leverage points at the national level and at the cross-border level is what we need to bring about this change. And I would like to conclude just by highlighting the very conducive collaboration between the ILO, the Office of the High Commissioner for Human Rights, and the Working Group on Business and Human Rights, as well as the OECD, established over the years on the business and human rights agenda, based on our international standards and instruments, as well as with many other international organizations that we are closely working with on this very important agenda. Important developments are happening in each of our organizations. And I think what is important is indeed connecting the dots. It is something that various speakers have already highlighted. Mainstreaming, connecting the dots, let's do it together. I mean, I saw there were many different slogans being used for that, but that is indeed important. Important developments take place in each of our organizations, but it is together that we are contributing to this broader business and human rights agenda, and that we are inspiring others to do so. So I thank again Minister Petri for the invitation and very much look forward to our continued collaboration. Thank you.
Mrs. Roland, thank you so much to you. Of course, it's shocking to learn what pandemic is doing to the world of labor. It's really terrible. And of course, we totally agree, Italy, since the first national plan 2016, there is this strong link with the the 2030 objective number 8. So, and we work together very closely with the Italian labor organization. It's really important, yes, to connect the dots, and thank you so much to bring your perspective so well and so broad to this panel. Now we go to the final, and then we hope we will have a few minutes for some questions that we received. But with the final, we go back to the Council of Europe. We have a presentation now from Professor Dr. Trigan Karpetian. It will be presented platform. So I will not say more, but Mr. Karpetian is the head of division of transversal challenges and multilateral project task force. And so, Dr. Professor Karpetian, the floor is yours. Thank you again. We organized this meeting together with Council of Europe, and we are very happy that there is this presentation because it's a concrete step that Council of Europe has taken on human rights and business. So thank you again, and the floor is yours.
Thank you very much, Mr. Chair. Thank you very much to all the previous speakers. I do hope that you can hear me because at some point I was kicked out and then I'm traveling, so my internet connection is not.
We can hear
perfect.
you.
Thank you. First and foremost, I would like to thank for the opportunity to speak at this event and to present the project that the Council of Europe is doing and is planning to do. As a matter of fact, the online platform, which has been—
Sorry, you have to speak a little bit closer to your microphone so that we can hear better. Thank you.
Do you hear me? Do you hear me like this better?
Yeah, thank you.
Better. Okay, I try to speak like this then. So once again, thank you very much for the opportunity to speak at this event and to present the Council of Europe's projects vis-a-vis human rights and business. I must say that the online platform that has been indicated in the name of the presentation in the agenda isn't exactly what I will speak about. Yes, that online platform, which was already referred to by our director, Mr. Poirel, in his opening speech, exists in that platform, which was created following 2016 Committee of Ministers recommendation, contains a lot of useful information regarding national action plans from the member states, as well as implementing actions that the member states are taking, along with a whole set of standards, Council of Europe standards, but also other international standards that exist in the field. And you know, all of you can go online and see what's available on that platform. So I will not be describing the online platform. What I will be describing is the Council of Europe platform for human rights and environmentally friendly and responsible business practices, which is in fact a project, a cooperation project that the Council of Europe is proposing, is a cooperation project which has not started yet. And yes, it's called a platform, but it's not called a platform in the IT sense of the word, but rather a platform for exchange, a platform for cooperation, a platform where different actors can sit together and discuss very complex issues, as all the previous speakers have noted, and find balanced solutions to those issues using, among other things, the Council of Europe mechanisms and Council of Europe tools. The context in which we are actually looking at creating this platform, and by the way, the platform and the project are not yet funded, so I am actually looking also and would like to thank the organizers for this opportunity once again, and call upon those who are interested also to support this project to do so. Because in the context of intertwining public and private interest, in the context where there are global corporations, big companies, where essentially they work in across borders, and their power sometimes goes beyond what we normally would assume a private actor's power to go. In a situation where companies working across different countries are able to de facto export human rights and environmental harm, and I'm glad that human rights and environmental harm are actually have been noted together in all previous presentations. So in the context where companies can actually use differences in regulation by, you know, setting up or going or exporting some of their business practices to countries where they're less regulated, there is a need to create mechanisms and tools that would allow tracking both supply chains but also product delivery chains in order to find solutions to reflect that harm or impact, as a matter of fact. Let's not speak only of harm, but impact, human rights impact, and environmental impact throughout entire business models. So the objectives of this project are to ensure, among other things, strong buy-in from businesses, and for through realizing the value of human rights compliance. And when I say so, what I mean is human rights do not necessarily have to represent costs for the business. Human rights can also represent significant value for the business. And one of the speakers before me spoke of business models and changing business or economic models to be able to shift the balance of powers. But we could also change the economic or business models in order to realize or incorporate the value of human rights compliance into the business value chain. For this, at a minimum, we need to actually have mechanisms to reliably track actual impact of business practices and consumers, be that on human rights or environment. Developing new environmental and human rights protection tools that could be used by the businesses and member states and this could include methodological tools, in addition to all the guidelines and methods that have already been mentioned, technological tools, for example, to be able to bring the information about all these impacts together, or legal tools by ensuring policy on national and international level that could ensure the all the above mentioned tools. So this is why we are proposing to create this privileged platform for businesses to access the Council of Europe expertise and exchange with other businesses, but also with member states, and most importantly, also with civil society organizations. Because as was mentioned already by previous speakers, civil society organizations must also be heard, and independent human rights institutions, be those formal institutions like ombudspersons, as mentioned in the presentation by Fra, or non-governmental organizations and human rights defense. Exchange analysis of existing best practices would be a first step in this, and best practices in measuring and assessing human rights and environmental impact along the supply chain. And here we can look into both formally required due diligence processes, but also the due diligence processes that companies undertake themselves for whatever reason, be that for CSR reasons, for reasons of securing funding, for example, through the banks, or for reasons of actually trying to improve the operations of the companies and making them more greener or more human rights friendly. And last but not least, based on that, this platform could discuss the development of practical tools to track and account for human rights and environmental impact of business practices. Now, one might justifiably ask the question, why should the Council of Europe be involved in this? There were a number of very respected organizations that spoke before me who've presented a host of measures, a host of guidelines, and actions that they are taking in order to address many of the issues that I just spoke about. Well, I do believe that the model of cooperation that works in the Council of Europe with 46 member states has been extremely successful in finding solutions to very complex problems by sitting together and finding consensus around both standards, the monitoring mechanisms, the monitoring of those standards, as well as finding cooperation models that work. The expertise that the Council of Europe has in this, standards and case law of the European Court of Human Rights in human rights, and quite rightly, it was mentioned from the very beginning that we should be speaking about human rights and business rather than business and human rights. And this is the approach of the Council of Europe, of looking at the entire question through the prism of existing human rights. And last but not least, experience, which I already mentioned, in monitoring, tracking, and solving very complex issues through cooperation between the member states, that can be applied also to this sector, that is already applied, as a matter of fact, to this sector through the work of the CDDH and other bodies, through the work of the court as well. So this is the platform that I wanted to present, along with the online platform that was mentioned, as I said before, by Christophe Poirel. But these are two different platforms. One is an online platform for info exchange. The other one is a platform that we are proposing for increased cooperation between all stakeholders that we need to cooperate in order to find sustainable, viable solutions, working solutions to the environmental and human rights issues connected to business that were raised by all the respected speakers speaking before me, and I'm sure those speaking after me. Thank you very much.
Thank you to you, Professor Karapetian. I mean, maybe the name sometimes are not that easy. So first thing, is very, very interesting that in this occasion there is this proposal. Of course, we as Italy, not only because we are holding the presidency of Council of Europe, but because we believe so much as the Secretary of State said, in the value of the Council of Europe, we have no doubts that what you said about the capacities that the Council of Europe has developed to create consensus, to create, to elaborate new strategies, new ideas, new ways of putting together different inputs to create a new path, it's something that can be used. Maybe let's hope really that your project will go ahead. It can be used also in the field of human rights and business. So we are really very happy. I think that if in future, when you want, if you want to share with us some also written at the moment in which you will feel right to do so, some proposal, etc., we are very happy to share it with all the persons that are participating to this workshop. In any case, we are very happy that there is this thinking in an important organization like the Council of Europe. I think that it's perfectly in line with all that has been said so far, with the idea of connecting dots, with the idea of acting together. So really, this is very interesting. We received some questions, two really. I would like to use these final minutes before the little break that we have. One is, it is something very interesting because our national plan, there is a measure on a certain kind of enterprises that are the enterprises in the media world, newspapers, television, etc., radio. So there is one question from one Italian civil society organization that is saying that it's high time to start to make courses, training for the enterprises that are in the media department. So first, I would like to know if any of you has anything to say about this. Of course, it will help a great deal if the business enterprises that are in the media world could be really involved in this part. Secondly, of course, there is somebody who said that it's very frustrating because it seems that it's true that a lot of things are said, that there are a lot of initiatives, but on the ground it's difficult to see the differences. I would like to say to the person that wrote this note that it's true, that every time that we speak about human rights, frustration is there, is part of, but it does not mean that things are not happening. It does not mean that there are, like we see today, organization, people that are really committed in trying to change the things on the ground, but it's very difficult to see real effects. But it does not imply that things are not moving. In fact, I must say that what Professor Surya Devia said about what has happened in the last 10 years, I remember when we released the first National Plan of Italy, 2016, we were the 9th country to do that. It was really something we were feel like pioneers. We are speaking only 5 years ago. Now we feel that it's becoming a mainstream, even if not so much as we would like, but nevertheless, there has been a huge development. And the point now is to go beyond, like was said, not only states, but also not only business, but also the rest, civil society, and of course sports and everything. I believe that Professor Karapetian, you want to take the floor again?
I would like to just respond to the question regarding the training.
Please, but you have to put your microphone closer to you, because otherwise we don't listen.
Yes.
Please.
Yes, I hope you do hear me better
Please.
now. I just wanted to say about the training that is already available, as a matter of fact, in the Council of Europe. It might not be directed specifically at media organizations, but could be used for media organizations as well. The Council of Europe Human Rights Education for Legal Professionals platform, which is an online platform for training, online training platform for human rights training, contains two very important courses. One is human rights and business, and the other one is human rights and the environment. And both of these courses could be used for different professionals, although the target audience is legal professionals, but I'm sure that they can be used also for media professionals. So we would be happy to work with different stakeholders in implementing these trainings and adapting them to be available also in national languages.
Thank you so much, because in the implementation of our national action plan, we will try to do specific training for the media enterprises. So we will, of course, talk to you again about this. So thank you so much. I don't know if there are other comments on what we heard in this session, in this first session of our workshop. I was really interested, and even if it's now more than 5 years that as president of the Italian Committee of Human Rights, I deal with this issue. We did 2 national plans. We did a revision of the first national plan, a midterm revision in 2018. We did the second national plan last year. Nevertheless, what I heard today is bringing new ideas, new vision, new blood to this path. So I'm particularly happy of this session. I don't know if any of you would like to add something. We had like a few minutes, 1 minute, but in any case, please, if there is any of you that would like to add something, is the most welcome. So we have now a short break. Surya, Professor Surya Devia, please.
Thank you. I think it was very interesting workshop with very interesting sessions. Because the media companies were raised, I want to also mention that perhaps we also need training courses and manual for journalists.
Yes, please.
Because journalists can be, because if you look at the journalism, they report on BHR issues, but if you look at the newspaper reports of journalists, they don't really refer to international standards in their reporting on many occasions. So I would strongly encourage all actors to also think of different levers of change. And I think the media personnel could be one of those levers of change. So if we can introduce them the relevance of international standards, and they can integrate those into their reporting. Thank you very much.
Thank you so much. This is, in fact, one approach that is very important, and we will try to do this in Italy in implementing the second national action plan, training for journalists in the media world. So thank you so much for saying this, and of course we will keep in touch on this to have also ideas, concrete ideas if need be. Thank you so much. I don't know if there is any other comment. So we will resume in few minutes, in fact, at 4:10. In 10 minutes time, we will have the second session on national experiences, and we will have the multi-stakeholder also dialogue with several persons from the world of business, the world of labor organization, civil society, academia. So we will meet again in 10 minutes. Thank you to all to be with us today.
la telecamera l'ha presa dall'alto, da lontano. Se ci rimettete, se ci rimettete il video.
Ok, possiamo ricominciare.
Il video col ministro in posizione. Perfetto.
Perfetto. Ci siamo quasi. I think we are again online.
Yes.
So thank you again for everybody, for all of you to be with us. We are starting now the second session of the International Workshop on Human Rights and Business. The second session is dedicated to the national experiences. So it's divided into parts. The first part, we have representative from Italy and other countries, member of the Council of Europe. So we are very pleased to have our guests. And then we have a multi-stakeholder dialogue with academia, civil society, business representative, and trade unions. So first thing, thank you again. As you know, we are very happy to have this workshop as Italy because we dedicated quite an effort in the last 6 years to produce the National Action Plan on Business Human Rights. Italy was among the first country in 2016, and then again in 2021, just last 10th of December, we released the second National Action Plan, 2021-2026. So for us is an important effort, is an important tool. We are very happy, therefore, to be able to talk about all this with all the possible relevant actors. So thank you again to be with us, to all of you. We have 3 representatives from 3 countries. From Italy, Ms. Benedetta Francesconi. She's the chief in charge of the OECD National Contact Point in the Italian Ministry of Economic Development. We have from France, Ms. Charlotte Blondel, legal consultant, sub-director for human rights, legal affairs directorate, Ministry of Europe and Foreign Affairs. And from Germany, Mr. Jonas Hein, legal officer, Human Rights Department, Federal Minister of Justice. So, thank you to the 3 of you to be here. We start, I'm sorry that we start with Italy, but we start with Italy. So we give the floor to Mrs. Benedetta Francesconi, a dear friend, and she is one of the pillars of our work in business, in human rights and business in Italy. So Benedetta, Mrs. Francesconi, the floor is yours. Thank you to be with us.
Thank you, Fabrizio, and thank you for your kind words. And distinguished speakers and audience, it is a pleasure for me to intervene today in such important workshop and to present our experience as Italian National Contact Point. First of all, I would like to thank Alan from the OECD for having introduced the guidelines and their evolution over time and future perspectives. As you may know, the national contact points for responsible business conduct are established by adhering countries to the guidelines by virtue of a legal obligation, since governments signed the OECD Declaration on International Investments and Multinational Enterprises. And in this declaration, it is foreseen that governments set up a national contact point to implement the guidelines. So the mandate of these national contact points is twofold. First of all, there is a promotional mandate. It has been said many times today that it is important to diffuse the culture of business and human rights, and I completely agree with this need. And a second mandate is to manage what we call, to handle cases that we call specific instances in the mechanism of the guidelines, which are with an approach which is a non-judicial grievance mechanism. And the final aim is to find an agreement between the parties, which are stakeholders vis-a-vis businesses in a difficult situation, where there is an alleged violation of the recommendation of the guidelines. To date, about 50 governments have adhered to the OECD guidelines. So we know that there are 50 NCPs all over the world, and this makes, from my point of view, a strong network and a community of practitioners that work every day in, on the ground, dealing with a wide range of impacts involving companies, either through their operations, but also through their supply chains. And thus, governments through the guidelines have set for strong expectations towards a responsible business conduct by businesses. And also the guidelines themselves, as it was recalled by Alan, are a benchmark, or as you may call it, a standard with regards to the evolving non-binding and binding rules in the area of RBC and also on business and human rights, such as, for example, they are mentioned in the proposal of the European Directive on Due Diligence, to which I will come later. Indeed, the inclusion of Chapter 4 on human rights in the OECD guidelines in 2011, and also the reference in the guidelines to the UN guiding principles, have strengthened the role of the NCPs in terms of business and human rights. I would just like to give some numbers just to give an idea of what we are talking about. And between 2000 and 2019, NCPs all over the world have handled more than 500 cases relating to company operations in more than 100 countries and territories. And the majority of these cases since 2011, as I said, with the introduction of Chapter on Human Rights, are for 57% regarding human rights specifically, followed by general policies which refer to due diligence practice, and also followed by employment and workers issues on 40%, and the environment for 21%. So you see that the percentages are not 100% if you sum up them. This is because as you may imagine, the human rights chapter comes always interlinked with other chapters, be it workers' rights or environmental rights or corruption, etc. So human rights are interlinked, unfortunately, also with other aspects. Another important number is that between 2011 and 2019, over 1/3 of all cases which were handled by NCPs resulted for 36% in an agreement between the parties, and approximately 33% resulted in a change in internal change in the business involved. As for the Italian NCP, since 2011, we received 18 specific instances, and 15 of them refer to human rights. So you can see that human rights are really at the center of these specific instances. On this regard, I would just like to mention one case where there was an agreement between the stakeholders and the business. And this case concerns an Italian company, Eni, which is also present today, represented by Mr. Alberto Piatti. And in this case, which concerned an Eni subsidiary in Nigeria, NAOC, and regarded an environmental issue and environmental impact of a plant of this subsidiary. Thanks to the conciliation of Professor Tullio Rodolfo Treves, the parties came to an agreement to solve the situation on the ground. And I mean, it's not here the place where we can give details. You have all the information on our website. But what is interesting for me is to stress that after in the follow-up conversations that we had with both parties, They recognize that there has been progress on the implementation of the terms of settlement agreed, and they confirm their willingness to continue the dialogue between the local communities in Nigeria and the company to reap all the benefits of the agreement reached. So that's just to show that there can be practical, and remedial actions applying the OECD guidelines. Indeed, we have spoken about due diligence, and which is the axis around which, the expectations on companies is built on. And you all know that this is referred to in many, the due diligence concept is referred to in many national and international non-binding and binding instruments. And that's why NCPs are more and more involved in all these processes. For example, our office in the ministry, the same where the NCP is located, is the national competent authority for the implementation of the EU regulation on due diligence obligations for importers of minerals coming from conflict and high-risk area. And we are also responsible for controls on obligations and to provide corrective measures and also eventually administrative sanctions if needed, of course. At the same time, we now have the European proposal of a EU directive on due diligence for a mandatory corporate due diligence. On this, I would just like to make one point, which is very important for us. I mean, it is very important for us to see how this directive will evolve, and which will be its final shape, because we think we need to understand more the coherence of the directive, both with the guidelines and also other international frameworks, but also with the NCP mechanism compared to the supervisory authorities which are set forth in the directive. So I think this is something, there will be a workshop tomorrow at the OECD discussing exactly these themes, more or less. And I think this is a very important aspect that we have to consider when defining the European directive in order to assure what companies and also governments are expecting, which means not duplicating, not confusing messages, aligning frameworks both at national and international level in order to assure a level playing field, and also make it clear which are specific instruments that can be used in order to apply business and human rights concepts. And the last point I would like to make, referring to Mr. Deva's speech, is the one on SMEs. I know that we Italians, we always speak about SMEs, but this is a natural consequence of the fact that we have many 19.9% of SMEs, but at the same time it's also linked to the fact that our SMEs on average are smaller than European SMEs, for example. So they need an important support. And what we see is a growing burden on these SMEs. Of course, I agree on the fact that also SMEs have to respect human rights. I mean, we cannot say the opposite, of course, but at the same time, we have to stress as governments and also as, a political message that is important to incentivize these SMEs in the supply chain in order to help them catch up with all these frameworks and standards, because otherwise, this becomes for them just a burden and not a positive tool. I mean, all these instruments and frameworks, etc. So we have to help them, we government, but also, I would say, also big companies towards their supply chain in terms of helping them catch up and really focus on what is the rights protection, instead of focusing on procedures, for example, or other things. So This is my last message, and I thank again the organizers and everyone for inviting me to this meeting. Thank you.
Thank you to Benedetta, thank you to Dottoressa Francesconi for this very interesting speech, and especially to highlight certain aspects of the Italian situation, because every country is different, of course, and it's very important to have a tailor-made also approach and to understand the peculiarity of each situation in order to be really effective in implementing the idea, the guiding principle on human rights and business. So thank you again, really. And we have now the second state, as I was saying, is France. We have with us Mrs. Charlotte Blondel. I believe you are in line. First thing, thank you to be with us. Second thing, the floor is yours. Thank you again to have accepted our invitation.
Merci beaucoup et j'espère que vous m'entendez bien.
Très bien, merci.
Bonjour à tous, c'est un plaisir et un honneur d'être parmi vous aujourd'hui pour discuter d'un sujet aussi important que celui des entreprises et des droits de l'homme. Merci aux organisateurs de cette journée qui jusqu'à présent a été très riche en informations et je suis très heureuse d'être parmi vous. Je suis ici pour vous présenter l'expérience française sur ce sujet complexe et essentiel que sont les entreprises et les droits de l'homme. Expérience française qui est d'abord celle d'un attachement évidemment au respect des principes directeurs des Nations Unies et aussi des principes directeurs de l'OCDE. Et on peut noter à cet égard l'adoption par la France également d'un plan national d'action qui repose sur la trilogie des principes requis, protéger, respecter, remédier. Un attachement aussi à une collaboration, une participation active au niveau européen et international pour le développement de normes et de principes sur ce sujet. Mais enfin, l'expérience française de ces dernières années repose beaucoup sur la loi du 27 mars 2017 relative au devoir de vigilance des sociétés mères et donneuses d'ordre. Et c'est sur cette loi que ma présentation va porter en priorité aujourd'hui, puisqu'il me semble que vous parler plus en détail de cette loi nationale peut permettre de mettre à jour des bonnes pratiques et peut-être de mettre à jour des idées pour progresser ensemble sur ce sujet crucial. Donc, la loi a été adoptée en 2017, comme je le disais, avec l'objectif d'empêcher la survenance de drames en France et à l'étranger et d'obtenir des réparations pour les victimes en cas de dommages portant atteinte aux droits de l'homme et à l'environnement. Cette loi donc française est centrée avant tout sur la prévention et la transparence, mais elle permet aussi certains modes de recours pour les victimes et je détaillerai donc ces 3 points, sachant que l'accent est vraiment mis sur la prévention en considérant celle-ci dans l'ensemble de ses dimensions de façon à essayer d'avoir une efficacité maximale sur ce point. Une précision, donc la loi s'applique à toutes les entreprises de plus de 5 000 employés, filiales comprises en France, ou plus de 10 000 employés à l'échelle mondiale au niveau du groupe et en France et à l'étranger. Alors la question des seuils est bien sûr importante et ce sont des débats actuels. Au moment de l'adoption de cette loi, le choix a été fait de cibler en priorité les entreprises les plus organisées et celles qui avaient le plus grand pouvoir de marché. Mais la question des seuils, bien sûr, est éventuellement à revoir ou à discuter. Donc, dans la loi de 2017, la loi impose un devoir de vigilance à ces entreprises qui consiste pour ces sociétés à mettre en œuvre de façon effective et surtout à publier un plan de vigilance, donc c'est-à-dire des mesures de vigilance raisonnables propres à identifier les risques et à prévenir les atteintes envers les droits de l'homme et les libertés fondamentales, la santé et la sécurité des personnes et l'environnement. De manière importante, ces mesures doivent concerner le groupe, donc les filiales et la société elle-même, mais aussi l'ensemble de la chaîne de valeur, c'est-à-dire les sous-traitants et les fournisseurs avec lesquels la société entretiendrait une relation commerciale bien établie. Ces mesures doivent être formalisées donc, dans un plan de vigilance qui doit être accompagné aussi d'un compte-rendu sur sa mise en œuvre effective. Et pour ce faire, le législateur est venu guider l'entreprise en imposant qu'un certain nombre de mesures figurent dans le plan de vigilance. Il s'agit notamment d'une cartographie des risques, destinée à identifier ces risques, bien sûr, de procédures d'évaluation, d'actions adoptées pour atténuer les risques et d'un mécanisme d'alerte ainsi qu'un dispositif de suivi des mesures. De manière très importante, le plan donc, doit être rendu public et inclus dans un rapport de gestion destiné à l'Assemblée générale des actionnaires, aux parties prenantes ou plus largement à tout membre du public. Et j'insiste sur l'idée de transparence puisque c'est très important pour la mise en œuvre effective des mesures visant à prévenir les atteintes aux droits de l'homme dans le secteur des entreprises. La loi prévoit également que le plan a vocation à être élaboré en association avec les parties prenantes, et là aussi c'est un point important, dans le cadre échéant d'initiatives pluripartites au sein de filières ou même à l'échelle territoriale. Et la disposition rappelle la nécessaire implication des parties prenantes et notamment des personnes directement affectées dans l'élaboration du plan de vigilance et dans sa mise en œuvre effective. Une grande avancée dans cette loi, et c'est le deuxième volet que j'aimerais développer, c'est la possibilité d'engager la responsabilité civile de la société en cas de manquement à ce devoir de vigilance. Le choix a été fait de s'axer sur le volet civil, puisque l'introduction d'un volet pénal peut créer des conséquences très complexes, notamment en matière d'établissement des faits et de coopération judiciaire internationale. Donc pour le moment, le choix français a été celui de la responsabilité civile. Sur ce volet, la loi prévoit deux dispositifs distincts de mise en œuvre. L'un concerne la conformité avec la loi à titre préventif, avec un recours au juge possible, et l'autre renvoie au droit commun de la responsabilité en cas de dommage consécutif à un défaut de vigilance. Donc sur le premier point, celui de la prévention, le dispositif de la loi prévoit qu'une société peut être mise en demeure de respecter les obligations prévues par la loi, et si la société n'y satisfait pas dans un délai de 3 mois à compter de cette mise en demeure, la juridiction compétente peut, à la demande de toute personne justifiant d'un intérêt à agir, lui enjoindre, le cas échéant sous astreinte, de les respecter. Donc ça peut être soit d'établir un plan de vigilance, soit de revoir ce plan, soit de veiller à sa mise en œuvre. C'est-à-dire que toute personne peut ordonner l'établissement, la publication et la mise en œuvre effective de ces mesures de vigilance, y compris sous astreinte. Donc ça, ce sont des éléments très importants pour l'effectivité des règles en matière de prévention des atteintes aux droits de l'homme dans le cadre des entreprises. Par ailleurs, en cas de dommage, toute personne justifiant d'un intérêt à agir peut introduire une action en responsabilité devant le juge visant à obtenir la réparation du dommage, y compris si celui-ci a lieu à l'étranger. Et donc, sur le fondement des règles habituelles en droit français de la responsabilité civile, les demandeurs devront démontrer un manquement au devoir de vigilance, un dommage et un lien de causalité entre eux. Et ces possibilités de recours ne sont pas purement abstraites, puisque depuis l'adoption de la loi française en 2017, nous avons déjà vu plusieurs actions menées sur le fondement de cette loi. La première concernait la société Total. Ces actions en justice sont toujours en cours, donc je ne pourrai pas vous donner beaucoup de conclusions par rapport à celles-ci, mais on peut espérer qu'elles apportent un certain nombre de réponses et elles ont déjà contribué à clarifier certaines questions dans la mise en œuvre de la loi, notamment sur la compétence des tribunaux, etc. Voilà, donc je terminerai en rappelant donc ces trois axes: prévention, transparence et mode de recours, et en espérant que mon court exposé sur la loi française sur le devoir de vigilance offre des pistes de réflexion. Elles en ont déjà offertes dans le cadre européen, mais bien sûr, c'est un souhait français de pouvoir continuer à contribuer au développement des normes en matière d'entreprise et droits de l'homme. Et sur ce point, je rends la parole à nos hôtes. Merci beaucoup.
Merci à vous. Merci à vous. Ça a été très intéressant de comprendre l'envergure de l'effort que la France est en train de faire. Bien sûr, on est tout admiré de votre loi. Ça a été un groundbreaking, vraiment une innovation énorme, et ça a fait énormément plaisir à tous ceux qui, comme moi, mais tous les restes que nous sommes ici aujourd'hui, nous croyons dans les projets des droits humains et la fondamentale nécessité de les appliquer au business, aux entreprises. Donc vraiment, congratulations, merci, merci, merci. On va voir si après il y a des questions qui vous, dans les cas, nous utiliserons encore de votre patience. Et merci d'être avec nous donc dans cette panel et de deuxième session. And now the third country that we have is Germany. Also Germany we know now is a law, so we are very, very happy that also Germany is with us. So Mr. Hein, the floor is yours. Thank you again for accepting our invitation and to be with us today. Mr. Hein, the floor is yours.
Thank you very much, Mr. Petri. Thank you to the presidency for the chance to speak on our law. And in fact, just a brief background, I work at the Federal Justice Ministry here in Germany, and Nicola Benson's team, whom you just heard. And we worked indeed on the German national law and will now work on the European directive as well. And so when we speak about national experiences, the experience that I derive from is the process from our national law, very similar to what my French colleague just stated. Now, what I want to do with you today is basically just give you a brief background on how we got to the law that we have today. And then I want to focus on two social political characteristics that I think inform supply chain laws generally, can be universalized also for national action plans, and two legal principles that I find are really important to these types of laws and that also informed our national law. And then fourth, I want to go into specific elements, specific policy tools that this German law derives in order to confront precisely these elements that we'll go through before. That's a bit what the plan is for the next 15 minutes. So just as I said, a little bit on the background. This supply chain law was adopted last year and it will come into effect next January 1st, 2023. And it is the culmination of our National Action Plan process, which took place from 2016 to 2021 as a multi-stakeholder process, very similar to Italy's. And this NAP voiced an expectation to companies that they would voluntarily implement the human rights due diligence requirements of the UNGPs. And it also included the monitoring mechanism that was there to verify whether this voluntary implementation would actually take place. And the idea was that if we actually found out that at least 50% of German companies voluntarily implemented these UNGPs, then there would not need to be a national law. And in 2020, we finally resolved the monitoring process, and it had an unambiguous result for some, in fact, unsurprising result, which was that only 13 to 17% of German companies, in fact, voluntarily implemented the NAP standards. And so the result of this was that now the German government had a clear mandate to start drafting and negotiating the supply chain law. So that's where we were back then. Now I come to the second point, which, as I said, I wanted to discuss two social political context elements that I find important because they can be universalized for other equal processes. And the first is that, and I think this is not a surprise to anyone working in this area, is that these supply chain laws are highly contentious, socially, politically, and economically. And that is because they cut through a vast array of legal and political issues and areas of expertise. And that, of course, results in very well pronounced and established interests and produces clearly antagonizing positions. And this, of course, is the context in which these supply chain laws are drafted. And I think there's two ways to confront this. The first is multi-stakeholder involvement, not as an end to itself, but as a form of voice and agency so that debates can be had and conflicts resolved before these issues are actually transposed into law. And the second, I think, is something from my personal perspective, is that it's important that the individuals in government working on these drafts have a clear sense of political direction and leadership and an atmosphere of cohesion and cooperation from which they draft these laws. I think it's important that lawmakers can work stringently towards a clear regulatory goal instead of being swayed constantly by changes in the political calculations. The second social point that I wanted to make is that I think there is inevitably going to be a sort of translation error in these types of laws. And this is because the cradle of business and human rights are the UNGPs, and they are a set of soft law principles, as we all know. And they are not a politically sanctioned set of regulatory obligations. And the first consequence from that is, of course, that human rights due diligence needs to be translated into the language of the law in a way that conforms to its principles. And this will inevitably lead to conceptual changes to the framework, and so also to frictional losses that in themselves frustrate expectations with stakeholders. And the second point that derives from this is that there are different understandings how this translation process should proceed. I think this is because soft law mechanisms, such as the UNGPs, they inspire the imagination and produce perspectives on the framework they construct that often are very incongruous. So this is connected to the problem that these laws are very contentious socially and politically. And this is good, in fact, as Professor Deva said, because the language of business and human rights has been universalized. And this goes to show that supply chain laws are simply one form in which UNGPs find an expression. But nonetheless, supply chain law regulation will be confronted with these frictions and therefore needs to find policy solutions to resolve them. And we'll get to that in a second. Now, I wanted to dwell a bit on two, I think, very main principles, legal principles that also inform supply chain law and supply chain regulation. And they are intricately linked to this translation error I just mentioned. And they were also, for our legal process here in Germany, central roadside constraints for drafting the German law. Now, the first of this is the principle of legal certainty. The German Constitutional Court states that laws must provide clear, determinable solutions and conditions such that the addressees can foresee the legal consequences attached to certain forms of behavior and thus adapt their behavior accordingly. And this is, of course, of particular importance when, as in the German case, punitive sanctions are attached to certain forms of behavior. And the second principle I wanted to mention, and I think this is all very well known to everyone here, is the principle of proportionality. And it, of course, requires that the extent of the burden on the addressee of a law must be reasonably balanced with the benefits that accrue to the general public or the legislative aim that is pursued. So I think just these two principles go to show that we are working in an entirely different environment when we're drafting supply chain laws than when we are talking about international non-binding standards such as the UNGPs or the OECD guidelines. And in fact, in the European directive, you see a number of references to precisely this differing framework. And again, supply chain law legislation must find ways to follow through on the promise of the UNGPs while also conforming with these legal principles that did not explicitly inform the construction of these international frameworks, such as the UNGPs or the OECD guidelines. So now I wanted to go into a couple of legal policy tools in the German law and ask the following question. How does the German supply chain law implement these lessons from its inception and the constitutional requirements that I just mentioned? And which policy tools does it include that may inform other similar processes? And instead of dealing or detailing the entire context of the law, and then you can find it online, it's available actually in English, I would just like to focus on a couple of key elements that I find important in this respect. Now, the first one is that in contrast to the UNGPs, the German law has a clear, specific definitions of what a human rights risk is. The UNGPs, as you all know, stipulate that companies have a responsibility to respect all human rights standards in the Central Convention. But the German legislator opted for clearly defining a set of human rights related risks that are particularly related to corporate behavior and supply chains. And this can be found in section 2, paragraph 2. As you know, human rights conventions are directed to states which have discretion in construing them. And thus these conventions take place in a methodological landscape that is ill-suited to deduce clear-cut requirements for the behavior of private actors. And this is why the supply chain law in Germany went this path. It tried to deliver on the principle of legal certainty, as I just mentioned, by defining in the law exactly what type of specific human rights risks corporate actors are expected to comply with. For instance, the law clearly defines the term of forced labor in its sense. And what is interesting is that you'll find in the EU draft directive and its annex, a very similar form of defining human rights related risks. And I think this also is a result of also in European Union law, the principle of legal certainty. A second policy tool that is included in the German law is the risk-based approach. And the law is constructed on a principle very central to the UNGPs, on this principle, which also conforms with the constitutional principle of proportionality, the risk-based approach of the UNGPs. The German law includes a clear definition of the standard of appropriateness in its section 3, paragraph 2. And it thereby signals that due diligence is not a results-based process, but a process-based concept. It includes, the law includes a catalog of criteria for what appropriate means. And it derives this catalog from the UNGPs and the OECD guidelines. And it has 4 elements that I'd like to just briefly state. The first element is the nature and the extent of the business relationship. The second is the ability of the company to influence the business relationship. The third is the severity or the reversibility impact or the probability of its occurrence. And the fourth is the nature of the causal contribution of the company to the adverse impact. These 4 criteria inform what is appropriate in the sense of the law. And based on these criteria, the company in section 5, paragraph 2, can perform a prioritization process of the risks it identifies. And I think this is what also UNGP principle number 24 clearly provides. But at the same time, it's a mechanism through which the burden on companies can be balanced with a legislative aim, which is the prevention of human rights. And human rights violations, I'm sorry. We believe that given a plethora of risks, this construction will enable companies to prioritize those measures that have the highest likelihood of impact and protection for potential victims. And just to add to what my Italian colleague just mentioned, it's also a way of balancing the obligations with the capacities of smaller companies, particularly SMEs. A third element, policy element I'd like to raise is the inclusion of stakeholders. And in fact, this is also something prevalent in the French law that we just heard. The German law is based on a crucial realization that the best antidote to preventing that the due diligence exercise is merely a tick-the-box process is the inclusion of stakeholders in the process with voice and agency. I think it's also important to mention that inclusion of stakeholders in and of itself is a form of remedy itself, right? And I think it's true, as Professor Deva said, that mandatory human rights due diligence cannot overcome imbalances of power between corporate actors and individuals. But I think the inclusion of stakeholders is a legal policy tool that goes a long way in reducing precisely these types of imbalances. And this is why the law includes a number of avenues through which affected individuals are included in the due diligence process. For instance, companies must include potentially affected individuals along the entire supply chain in the construction and implementation of the risk management system. They must also anonymously process complaints of all potentially affected individuals and include them in their resolution. Also, the law has created a new form of representative action in law for NGOs and trade unions for lawsuits filed before civil courts. And finally, and this is also can also be found in the EU directive, any individual can file a petition to the supervisory authority, and that supervisory authority must investigate the demand if the requirements are met. So all these elements relate to the clear recognition that only through the inclusion of stakeholders on the ground can the due diligence process really transform into an effective preventive device. So at the same time, I think this construction allows for conflicts on interpretation and facts to be resolved within the process itself, rather than in judicial proceedings ex post facto. And this is something I think that derives from the experience we had with this law in its inception. So I'm coming to an end now. I think these are all legal policy tools that the German legislator constructed to confront the legal and social dilemmas I mentioned. And it's crucial to point out that they're just one of many forms to do this, but they are also forms of striking a balance that might inform other processes, similar processes. So to those of us in government that have had the privilege to work on this law, I think the EU process now will be a form of déjà vu. But we have learned what Isaiah Berlin once said, that out of the crooked timber of humanity, nothing completely straight was ever made. We, or I would add, though, that for a tool to be effective, it has never needed to be straight. It really only needs to work. And we hope that the German law does precisely that. Thank you.
Thank you so much, Mr. Rein. Thank you so much, Jonas. It was very interesting to hearing you, to listen to you, because you gave us a picture so with such a depth. And also, I was really following you where you were saying that there is the need to be really effective, to involve the civil societies, to have a multi-stakeholder approach. This was already said by previous person, the previous speaker in the first session, but it's really interesting to see when we are speaking about a country like Germany that has done a law and is applying it. So, I mean, it's very, very important to understand that in practice, these things must work only, and they can work only if there is real involvement of the multi-stakeholder approach and the involvement of all the different parts of our complex societies. So really, thank you a lot. And now, in fact, the whole idea is, as all we know, is to have always a multi-stakeholder approach. And now, in fact, we have the second part of this panel. It's dedicated to a multi-stakeholder dialogue. So I hope that here there will be some ways of understanding the issues of human rights and business from different perspectives, and to see in which ways we can understand better the issues at stake. We have with us four representatives of four different aspects in the multi-stakeholder dialogue. They are all persons that we know quite well, and we have interaction with them since quite some time. So I'm very, very happy to have them with us in this panel, because I know that they will bring an interesting point of view. So we have with us today four. We have Professor Marco Fasciglione. He's a researcher at the Law Center, CNR, and Director of Business and Human Rights Summer School. We have Professor Senator Francesco Martone, spokesperson Rete in Difesa di, which is a network of association. We have our friend Dr. Alberto Piatti, head of the Sustainable Development of ENI. And we have finally Mrs. Silvia Borrelli, Professor Borrelli, is Professor of Labor Law, University of Ferrara, and she's member of the CGL, which is one of the most important Italian labor organization. So again, thank you to all of you to be with us today. And I will start with, as we wrote in the program, with Professor Fasciglione. Marco, the floor is yours. Thank you again to be with us. Thank you again to have accepted this invitation. And again, the floor is yours.
Thank you very much. I hope you can hear me, isn't it?
Perfectly.
Thank you, great. Greetings from the National Research Council. I speak today as international law academician and researcher, dealing since long with the business and human rights realm. Many thanks to the Interministerial Committee and in particular to Minister Fabrizio Petri for this kind invitation to speak briefly to this important workshop, which gathers several institutions of my past and present professional life indeed. The Council of Europe, where some years ago I have been working at the European Court of Human Rights as legal advisor at the registry of the court, as well as the European Union Agency for Fundamental Rights, where currently I am a alternate member of the management board. So I'm very glad for this opportunity, Ministro Petri. I'm going to stress some points that, according to my point of view, are crucial when try to outlining future trajectories and scenarios concerning business and human rights realm, as well as when trying to taking stock of experiences, either national or supranational or international experiences. First point, I am very glad to see that the efforts that international institutions, states, the private sector, as well as the civil society organization are deploying in order to put human beings and their rights at the heart of economic order of our society. From this side, we all have to change our mindsets. And in this respect, business and human rights movement is a game changer. We need for collaborative solutions stemming from the participation of the different actors and stakeholders, this being indeed the only avenue apt to realize the real change and progress for meeting those global challenges like climate change, mentioned before by speakers before me. In this respect, let me mention very quickly the positive fact of the inception in the 2021 of the Italian NGO campaign for the establishment of a human rights due diligence directive, the Impresa 2030 campaign, the Business 2030 campaign. The initiative, the campaign, fills in an important gap in the national NGO movement in the direction of joining efforts toward developing responsible business. Second point, business and human rights is not the same of corporate social responsibility. This is a very important point. CSR is a voluntary movement about what company may do and want to do in respect to responsible business conduct. But this is not business and human rights. Business and human rights, or human rights in business, is thinking about the impact and the harm stemming from business activities on people and on the planet, and implies a shifting of mindset, not only from companies, but also from government institutions and international organizations, etc., etc., etc. Third point, 60 years, more than 60 years also, of CSR movement suggest us that voluntary initiatives alone are not sufficient, and the time for binding rules has come. Discussions regarding this issue have been ongoing since decades. Nowadays, we have new pieces of legislation at the national level, as well as at the international level, supranational level. We have mentioned in this afternoon the France loi sur les devoirs de vigilance adopted in 2017, the Germany supply chain law adopted in 2021, and also the directive, the draft directive at the European Union level, as well as the UN negotiations concerning the Treaty on Business and Human Rights. All these instruments are contributing to reverting the traditional landscape and inspiring new thinking and interpretations. However, and this is the fourth point, there is no either or approach. Often we hear statements such as, we do not need the European Union directive, or we do not need the UN treaty, or we do not need a legislation at local level. Well, this is a mistake. We do need all these instruments. We do need the multiple solutions and the richness stemming from their diversity. Fifth point, this important bulk of regulation already existing or under adoption should be aligned with the UNGPs, United Nations Guiding Principles, as a part of a larger goal of policy coherence. Creating coherence, be it at the European Union level or with laws and processes existing in other parts of the world, is crucial. Indeed, creating new norms that conflict each other, or worse, which lower the bottom line, would bring us backwards, not forwards. Indeed, even though without being an instrument with a binding nature, the UNGPs have become the generally accepted reference point in business and human rights field. They have been largely acknowledged and applied to companies, governments, and international organizations, such as Professor Suryadeva has underlined this morning. Therefore, it should be avoided that future instruments on business and human rights depart from agreed notions and practices. As for instance, an example is the human rights due diligence notion encompassed in both the draft directive and the draft treaty. This notion departs from the one of the UNGPs. This is a pity. Once considered the fact that human rights due diligence notion under the UNGPs has been generally accepted and applied, is already applied by several businesses worldwide. Another example is the already mentioned issue concerning the scope of these instruments. We should not limit the application of business and human rights instruments only to large companies or specific sectors. And this because it is not the size of a company that creates irresponsible behavior, but the impact of its business activities. Let's think to the case, just to remain within the current tragic international events, of small enterprises operating in conflict-affected areas, which may be associated to gross human rights violations or to commission of international crimes. For such companies, the UNGPs not only does not foresee any exemption from corporate responsibility to respect and from due diligence, but on the contrary, require a heightened due diligence. In other terms, a reinforced due diligence process. Sixth point, we do not need solutions replicated from 60s and 70s dynamics polarizing states has pros or cons around opposite solutions. We do not need, in other words, and here I'm thinking to the negotiation concerning the UN treaty, another treaty from the United Nations mirroring the fate of the International Convention of the Protection of the Rights of Migrant Workers and Members of their Family, adopted in 1990, where all the states having ratified that convention are sending states, while no major immigration country has done so. It goes without saying a similar outcome of current negotiating path and the future treaty on business and human rights with a low level of signature and ratification, or even worse, ratified only by states in the global south with the absence of boards industrialized states, would be undermined in its effectiveness. Last point, and I'm going to conclude, the role of state institution in this process, which is a point which is very, very close to me. States are at the intersection of supranational and national legal regimes. Therefore, states are well positioned to further on business respect on human rights. And UNGPs recognize this pivotal role, reminding us the necessity they lead by example by applying, for example, human rights due diligence requirements to their own companies, state-owned enterprises. And this is another missing element in the draft of the EU directive. UNGPs also urge states to apply that wide range of measures that they have the power to enact, both at national level or at international level. And EU countries have gone through a long path here. Italy too has done a lot in this area. However, as acknowledged by the very same National Action Plan adopted by CIDU, a lot remains still to be done. Minister Petri, thank you very much.
Well, thank you, Professor Fasciglione. Thank you, Marco. It was very not only interesting, but especially very well presented and articulated. So I think that you gave quite a valuable contribution to our session, second session, and thank you again. And of course, it's true that a lot remains to be done, but thank you again, really. Now we have Senator Francesco Martone, as I was saying, a spokesperson for Rete in Difesa D. He's a long-time human rights activist, very well known in Italy and abroad for his work in the field of human rights. So we are very happy that Senator Martone has found the time to be with us today. Thank you again to be with us, to have accepted our invitation, and the floor is yours.
Thank you so much, Ezio, and thanks for everybody that has been speaking this far in this workshop that is extremely illuminating because it offers a very important space for interaction and dialogue. I'm going to speak mostly about the issue I'm working on at the moment, that is human rights defenders, and in particular on how in Difesa D, the nationwide network of Italian citizen NGO organizations and NGOs, almost 40, that have been working on human rights defenders, together on human rights defenders for the last 4 years. I would like to first of all make a very kind of semantic commentary, because we are here sitting in a multi-stakeholder dialogue, but in fact, one of the elements that needs to be taken into due account when discussing about impact private sector activities on human rights, also to engage with the proper right holders, in particular affected communities or workers, worker unions, indigenous peoples organizations, environmental rights defenders, for the work they do or for the commitment they undertake are on the front line of threats and intimidation, arrest, and other violations of rights. And I think this is not only say distinction, it's also about how to fully engage and properly engage with all the different parties that are part of this kind of business and human rights realm. As I said, I represent Difesa D. Difesa D is also an active member of an international coalition called the Zero Tolerance Initiative that has been launched by a group of indigenous peoples and rural local community and Afro-descendant representatives worldwide, working with a set of important international organizations working on business and human rights and indigenous people and environmental rights defenders. And we have been engaging, especially in Italy, in a dialogue with CIDU as regards the integration of language and reference and commitments on human rights defenders in the National Action Plan. And this is also partly due, partly consequential, let's say, to a resolution adopted by the Italian Parliament, I think it was 4 years ago, when it was the Italian Chamber of Deputies committed Italy to fully and strongly represent and support human rights defenders worldwide and the international level. This, in fact, then led to the campaign for it that was launched by Italy for taking seat in the Human Rights Council. One of the pledges throughout this campaign was really to represent the issue of human rights offenders also at that international level. Now, the mandate of Italy has been doing that, for instance, following up on issues and human rights offenders could be a very good way to extend this legacy. Why it is so important to discuss about how to fully implement and properly translate into practice international commitments on business and human rights offenders. And let me give some figures to really ground this discussion on reality, on actual reality on the field. In 2020, according to data from Global Witness and Frontline Defenders, as many as 600, this data more clearly are from Business and Human Rights Resource Center, I'm sorry. The Business and Human Rights Resource Center registered at least 600 attacks on defenders working on business-related human rights issues in the last year. And 1/3 of those were related to the lack of meaningful participation, access to information, and in the specifics of those peoples, the lack of respect of their rights to prior informed consent. In more than half of the cases, defenders were experiencing judicial harassment, so-called lawfare, and at least a fourth of those attacks were non-women defenders. We can already see here that, you know, one of the elements to take into due account when talking about, you know, implementing human rights, but also human rights offenders, is to take into due account the so-called asymmetries of power and asymmetries of access to judicial remedial action and judicial system. For instance, when you talk about women defenders, we have to take into account gender considerations, existing patriarchal structures in many countries. When we talk about indigenous peoples, we have to take into account also existing colonial cultures in many of those countries and a history of historical, let's say, exclusion from you know, from policy spaces and from real actual consultation. Another element, considering that the National Action Plan of Italy is also strongly referring to the imperative for an energy transition and to tackle climate change, is that the distribution of areas, of riskiest areas for defenders that are mostly environmental, to the figures, is that most of them were active in the field of mining and extractive, and the others in the field of agribusiness. The extractive sector is very relevant because if you look at projections by Goldman Sachs and the World Bank, the transition towards, you know, fossil fuel-free future and low emission economic systems will have a very long in terms of expansion of extractive activity, mining, especially in related infrastructure in the coming years. So it's something that needs to be taken into due account, also in terms of what might be the direct or indirect impacts on indigenous peoples and communities living as the resource rich and are very fragile in ecological terms. The interesting is the Global Witness as well, you know, produced a report last year evidencing, as I said before, that almost half of the violations or attacks of defenders were related to environmental rights defenders in various countries, mostly in Latin America and in Asia. So this issue is very relevant also for Italian companies working abroad, especially infrastructure, like or Italian companies import or is supply chains that seem to be the riskiest for defenders, and so also possibly the riskiest in terms of potential human rights violations, but also the ones that could be the most interesting in terms of experimenting and testing innovation as regards implementation of due diligence. And let me also add mandatory requirements for respect of human rights. The issue has been very much at the center of the work of various international institutions. I mean, let me just commend here a very important statement by the Council of Europe Commissioner on Human Rights last year on the role of environmental rights defenders and the responsibility of sex business. But also, I would like to recall the important report produced years ago by the former Special Rapporteur on Human Rights Defenders of the UN, Michel Forst, with whom we would have been a very direct interaction in the past. And he was focusing mostly on the role of business and human rights. Actually, he was introducing an element that is a little bit innovative in terms of what we've been discussing this far, because both him and also the UN Working Group on Business and Human Rights, the recently published guidance on business and human rights offenders, we're going a little bit beyond this distinction between duty of states and responsibility or diligence for countries, because I say, in case states are omitting to fulfill their obligation of human rights, it's up to the companies to fulfill the states. So it's a very interesting step ahead, I think, and this needs to be taken into due account. Interestingly, and this leads to another point that was also mentioned by the previous speaker about the need and the urgency for Italy as well and for EU member states to support the speedy finalization and ratification and signing of the international binding treaty on business and human rights. That is one of the key pillars human rights and human rights. Interestingly enough, let's say that companies and private sector have been following up to some of these calls. In fact, in the last years, we have been registering a growing number of companies, private sector actors, that have been making statements, have been committing, have been introducing policies on human rights defenders. And some of them are actually in the forefront. Let me mention a few, like Cargill, Unilever, Adidas, Coca-Cola, Tesco, and H&M. There's been very important commitments also by international financial institutions like the IFC or by the FMO. Actually, incidentally, FMO decided to have a human rights defender policy after they were targeted by a global campaign for their engagement in a destructive dam project in Honduras that costed the life of our sister activist and indigenous leader, Berta Cáceres. So there are interesting elements in place. Zero tolerance initiatives, also some of these important companies in the global supply chain sector, also with investors. I was directly engaged in talking to the Investors Alliance on Human Rights, that is a global network of investors totaling almost $2 trillion dollars investment portfolio, and they are actually introducing policies on human rights defenders. The International Financial Corporation of the World Bank, as well as very strong policies against reprisals against the defenders and whistleblowers. That means that one of the elements that has been taken up in the interaction between civil society organizations and business is the concept of shared space. So in fact, and this has been also reflected by the work and the recommendations by the UN Working Group on Business and Human Rights. Respecting human rights is not only important to prevent reputational risks by companies, but it is also important and crucial to do good business. For instance, listening carefully and attentively to the concerns by human rights activists and defenders, engaging these in the very beginning and fully respecting their rights to access to information, their right to be consulted, and for the indigenous peoples, the right to free prior informed consent, is actually a guarantee also to business well, and not only to damage to their reputation. And in fact, the role of business and private sector contributing to the advancement of human rights is now a fait accompli, especially by themselves, but also by the international sector. I would also very quickly refer to the ongoing discussion on the EU human rights due diligence regulation, and just very quickly refer to an important statement by the current UN Special Rapporteur on human rights defenders, Mary Lawler. We have also been talking to her on this. Basically, she's urging the Commission to fully integrate human rights defenders' obligations and language also in the elaboration of the human rights due diligence of the EU for the reasons I've been trying to explain previously. Let's go to the core of the work we've been doing and the discussion we've been entertaining, and also through the in DFSD with the Zero Tolerance initiative. the Italian National Action Plan on Business and Human Rights. This new National Action Plan, in particular on the issue of human rights offenders, contains some innovative language, not only in terms of recognizing, let's say, on paper formally, the contribution of human rights offenders, but also clearly stating the commitment to promote and support the implementation of the UN rules on business and human rights offenders. This is a very important instrument that tries to give, let's say, indications to states, but also to business on how to properly commit and fulfill obligations on human rights due diligence, and also now to fully support international obligations on rights offenders. It is very interesting because the working group itself, it's too bad that the chairman is not with us anymore, but I'm pretty sure that he will be able also to provide you with copies of the guidance itself. The guidance itself recognizes the important role of human rights offenders as a crucial part of the business and human rights ecosystem, and also in the role in enabling and supporting human rights due diligence. It to justice. What the guidance says is that there is a need to shift approach and ensure that companies actually consider the respect of the offenders and the respect of human rights as a fundamental element of their activities. Because, I mean, one element that needs to be pointed out is the bridge to be, the gap to be bridged between reality on the one hand, and the figures I was reporting to you show that reality on the ground is pretty much far away from the theoretical and commitments of principles. And this needs to be addressed fully with adoption of instruments of accountability, of monitoring, of redress, grievance, but also of kind of penalties for those companies that are actually not fulfilling their obligations on human rights. And let me just read some data to show how far we are yet to accomplish the final goal. The latest report of the Corporate Human Rights Benchmark that is done by the research centers for 2021 has been reviewing 230 companies worldwide in various sectors, from automotive to agriculture, agribusiness, infrastructure, and so on and so forth. And the research pointed to the fact that only a minority of those companies demonstrate actual commitment to take human rights seriously, in spite of that they have human rights policies in place. And that there is a disconnect between commitments and statements and policies and performance on the ground. This disconnect needs to be seriously tackled, also to ensure that all the commitments undertaken at the national level, also the discussion that are being undertaken at the national level in France and Germany, for instance, or at the EU level, are not really to be empty words. We do think that in this sense, the National Action Plan in Italy can offer an interesting space for Italian companies and civil society and international institutions and organizations working on business and human rights defenders to try and discuss together and work together. The NAP, in fact, refers to the possibility of a pilot program for the application and the implementation of the UN guidance business and human rights offenders. We do think this is a very important starting point, but it should not be an academic exercise, but a space where Italian companies can exchange best or can discuss with other companies that are already doing the best practices on these issues, or with civil society organizations or other institutions to understand how to fully implement commitments on human rights offenders. In particular, we are, very much in support of zero tolerance commitments, commitments to zero tolerance against attacks on defenders and against reprisals on defenders. And we do think that this could be a very opportunity, and in fact, we do also think that beyond the actual recognition of the possibility of a program at the national level, there needs to be a sort of a roadmap that is really that provides evidence of the effective will to fulfill this potential. So I think that to cut the story short, I think I jumped beyond my time. And we envisage the possibility of some dialogues among Italian companies that are already having human rights defenders policy in place, or companies that would like to do that but need to have some better understanding about how to do that and how to implement that. And then also technical seminars to understand together how these policies get put in place, how can they be monitored, and what kind of accountability needs to be ensured to make sure that companies fulfill these obligations and transparency is guaranteed. We do think this could be a very interesting opportunity, as I said, and I really wrap it up here. This could provide a pioneering opportunity for Italy, because, as I said, we don't think any other national action plan this far has such an explicit reference to guidance and to a potential pilot program to pilot them together with sector and civil society alike. I would like to thank you again for the time that was given to me. I hope I did not spill over my time, and looking forward listening to the next speakers. Thank you so much.
Thank you to you, Senator Martone and Francesco. Thank you. It was very interesting what you said, and especially there is one point that as president of the Interministerial Committee for Human Rights, I'm very happy, is that doing this national plan, like the one on women and peace and security, we have two national plans. The one on women and peace and security was written together with civil society because there was a smaller group, but the point is ownership. For business human rights national plan, we could not do really a working group to write it, but we did two public consultations, so we may make a huge effort. And what you were saying about the text, about the fact that we are trying in the dimension or in the field of human rights defenders to put the heart, beyond the obstacle, like we say in Italian, is very important, because it shows that there is this idea of ownership that arises when there is a real consultation, a real dialogue with civil society is very important. So thank you again for your intervention. It was very, very important for us. And now we go to the other part of the multi-stakeholder dialogue. We go with the enterprises, with the business enterprises. So we have with us Dr. Alberto Piatti, is the head of sustainable development of ENI. So we are again very happy that Dr. Piatti is with us. Thank you for accepting our invitation, and the floor is yours. Thank you again to be here.
Good afternoon, and thank you for this invitation that allowed me to share our cultural and human rights. But I have to start in this difficult time with the word out of the door, reminding to me and to you what is the spring, the cornerstone of the human right, that before being rules are a concept of the human dignity, first of all. And the human dignity is molding all our activities, including the respect and promote and prevention on human rights. I like to use a sentence from the author of The Little Prince, Antoine de Saint-Exupéry. If you want to build a ship, if you want to build a boat, don't drop up people to collect food. Do not assign them tasks and tools and work. But first of all, explain them the endless of the immensity of the sea. The immensity of the sea, the nostalgia of the sea is the human dignity. If we have this vision, we have to move ourselves according to the respect of the human being dignity. The journey of ENI, we can date the journey of ENI on human rights with our funder that at the early beginning, in a disruptive way, changed the paradigm at the time of the relationship among peoples and state. Probably is the reason of the accident of his plane. But more recently, at the end of the 19th, we keep the item or the issue of human rights in a very strong way. In 2016, we had a workshop chaired by our CEO, Claudio Descalzi, raising awareness on human rights in its activities with several external stakeholders, particularly with the Danish Institute of Human Rights. Starting from that has been shared with the top management and a cascade to all the company. In 2017, a multifunctional working group with 150 colleagues of 50 business line and support function worked to identify the gaps that we had at that time, and in order to identify the silent human rights issue, and to draft any statement on respect on human rights that has been approved by our board of directors in 2018. The statement that you can find on our website is a cornerstone of our commitment on human rights, in line with the UNGPs, of course. The silent issue has been clustered in 4 items: human right in workplace, human right in relation with supplier and other business partner, human right and security, and human right in host community relationship. I give you, due to the lack of the time, some example. On procurement, we have adopted a model that allow us to assess and monitor the respect of human rights in procurement process, with also possibility to realize audit inside and to verify that the rules, the ENI rules, has been applied. We have also a risk-based approach for the projects in the program in the country where we rely a higher risk, like Angola, Mozambique, Mexico, Oman. With the third party, we realize a specific human rights impact assessments in order to mitigate and to act an action plan in order to be compliance with the human dignity, as I mentioned this before. The same for our impact of security. We are closing the process to be member of the Voluntary Principles Initiative, and we think that within a couple of months we will be a member of that. But all these things need also an internal, integrated, continuous improvement. That we realize this continuous improvement through a dissemination of training course. We reach 27,000 people of ENI population. The process of MBO, starting from the top management and in a cascade way, reach all the people that has responsibility on the business. And last but not least, we have internal rules that are the guideline for all the population of our activities and workers. For this reason, probably we has been listed as best performance in 2020 in the corporate and human rights benchmark among 199 companies of several different sectors. Well, taking in mind all this process, we have to recognize also that any corporate human rights approach cannot limit itself to prevent. And this, I open the second part of my intervention. We do believe that we have to be an actor in promoting human rights. Any approach to human rights has indeed a double dimension, respect and promotion. Promotion for the workforce means diversity and inclusion, high standard of worker protection, and these we pretend that our guideline and our rules will be applied, must be applied also for our supplier. But I want to spend more time on another aspect. You know, the ENI is present in 64 countries, and we have also a strong presence in Africa, particularly in fragile countries. In this condition, in this adverse condition, themselves full potential negative human rights impact. And what we are trying to do is to promote and to remove this bad condition with our sustainability activities that we call local development programs. We invest every year 100 million in the sector of access to energy. Just to give you an idea, we realize 3 power plants in Nigeria and in Congo, and we are able to give affordable and sustainable energy to more than 20 million people. Off-grid energy, clean cooking, economic diversification, particularly in agriculture sector, quality education and professional training, access to water, water and sanitation, health. How we can do these activities? We are in a strong and continuous dialogue with the local stakeholder, with the civil society organization, with the local authority, in order to face the real need of the people that are living in the country, in the hosting countries. But we are not able to do all these very important tasks. The magnitude of deployment is so huge that we are promoting Alliance for Development with local society, UN agency, NGOs, and local authority. I said that we invest 100 million per year. In the next 4-year plan, I give you only few number, excuse me, we target to reach 1 million people in quality education, infrastructure, access to energy, economic diversification, access to water, and health of the community and the people that are living there. The two approach in high dimension of prevention and protection is also in line by the recent report by the Platform on Sustainable Finance on Social Taxonomy. We are ready to share in our voluntary report that you can find all the detail that I'm synthesizing now on our website with the next European taxonomy. And another key point that has been mentioned is the due diligence. We do believe that a universal rule on that could be very useful in order to boost and to accelerate also for that company that stay behind without involve and engage themselves so strongly in the issue of human rights. We welcome the due diligence norm on business and human rights, but at the same time, he would like to stress that we cannot reduce the due diligence simply as a simple problem of compliance or liability, something to be compliant to, because the prevention, the promotion is something more that to be aligned with the rules. And we come back, I'm closing my intervention, to the human dignity. If we do not have in mind that we are talking of human being and not numbers, it's quite difficult that we solve the problem. And second, I thanks again for this opportunity, because all the actors have to play together to improve the culture of human rights. Our journey will continue into the future. Thank you.
Thank you so much, Dr. Piatti. Thank you so much for this presentation of INAI activities and engagement. I remember a few years ago, we had a moment in which we shared our thoughts. You were defining your plan on human rights. And so I know how much you care. Of course, nothing is simple. So I think that what you said, the whole approach was of course very interesting, but what you said at the end, that we must be together, is really the most important thing, because we have to have a dialogue, and in this dialogue we can at the same time control each other and grow together. The challenges are so much that it's illusory it's an illusion to think that any actor can do by itself. It is not easy sometimes to do things together. So I think that a workshop like the one that we are having today, it's an important moment to try to understand that we have all really to work together. It's easy to say in words and more difficult to do in action. But thank you. Thank you, because your engagement is very clear and at the same time also effective. So it's very interesting for us to have listened to you. And now we go to the next and last, but not least, of course, member of the second session is Professor Silvia Borrelli. She's Professor of Labor Law, University of Ferrara, and she's the member of the CGIL, which is, as I was saying, one of the most important Italian labor organizations. So thank you, Professor Borrelli, to be with us, to have accepted our invitation, and the floor is yours.
Thank you very much for the invitation. I will be very, very short because many important things have already been said by the very important speaker that talked before me. But I just would like to start from my experience as a labor law researcher working with trade union, because we have recently published a report on 6 case studies on subcontracting and supply chain. There were case studies concerning different sectors: garment industry, construction, transport, food and agriculture. They were national cases, transnational European cases, and global supply chain. So they were quite representative cases. So in this report, we found out that in all these cases, there are several labor exploitation. Then we detected as well a volatility of the subcontracting companies. So basically companies appear and disappear very quickly. Subcontracting, we found out that subcontracting is a risk management strategy that is set up in order to separate power from profit and power and profit on one side from risk and responsibility on the other side. Then, notwithstanding the many labor exploitation that we found, we didn't find any worker complaints. So we discovered that workers, even if they are exploited, they never protest, they never go before courts. And last but not least, we discovered that it is very difficult for trade unions to exert their right in this context, and it is very difficult to organize collective action. So when we read the Commission proposal on due diligence, we were very happy to discover that this proposal tried to create a binding form of due diligence. But then when we read the text of the proposal, we immediately saw about our cases. And the question is, can this proposal change something in the cases that we have studied? The answer is no. The current proposal would never change anything. So nothing will change with the current text of the proposal. Why? First of all, because of the scope. The scope is very limited. According to the Commission, only 9,400 companies fall inside the scope. I tried to find out how many Italian companies are inside the scope, and I discovered that more or less only 150 Italian companies are currently inside the Commission proposal. Second, the material scope is very limited. And I'm very happy to talk today in a conference organized by the Italian Presidency of the Council of Europe. Because if you read the Commission of the proposal, it's quite offensive because the proposal never considered the European Convention of Human Rights, the European Social Charter, the Charter of Fundamental Rights of European Union. So all the European standards that are very important for us, they are not there, they are not considered. Then the proposal does not strengthen the trade union right. Basically, trade unions are never mentioned in the proposal. They are mentioned only once on the collective procedure. Then the proposal doesn't set up tools to facilitate access to victims and does not modify the international private law. So it does not modify the current rule on the applicable law and on the competent judge. It does not establish any form of strict joint liability. So just to be short, we are in favor of a binding due diligence obligation. We would like to have a binding due diligence obligation, and we would like to have a directive on a binding due diligence obligation. But this directive should help in solving the problem that we have detected during several field research that we have performed. In particular, we need a directive that tries to solve labor exploitation, company responsibility, and trade union marginalization. And I'm very happy that many speakers before me underlined that one of the main problems is power imbalance. And strengthening the trade union role, it means really affecting this power imbalance, because trade unions are a counterpower and they need to solve these power imbalances. So trade union should be part of the multi-level dialogue that we all would like to develop in order to solve labor exploitation and human rights violation. Thank you very much.
Thank you to you, Professor Borrelli. Thank you for this intervention. Thank you for the fact that you were so clear. Sometimes the dialogue means that we have to say exactly how we see things, otherwise there is no point to have a dialogue. So really was very, very interesting your speech. Thank you again to have accepted to be with us today. We have arrived with at the end of the second session. Of course, we have a few minutes left. I will just try not even to make any sort of conclusion, because it was so rich, so full of ideas, different vision, that I won't dare to summarize anything. But I would like just to take one of the threads that was there. I believe that the basic point is the point of imbalances, or asymmetry also, but basically imbalances. So we are in front of a world that still has so many imbalances. The pandemic, unfortunately, has but aggravated the situation. So really, vulnerable categories are even more vulnerable, and the imbalances are really stronger than before, as we have heard. So in front of this, the tool, the approach of human rights and business remains a very important approach. As was said, it touches all the possible fields, so it can be really very useful, is correctly used. So I think that the idea of an holistic approach is fundamental, an approach that goes beyond states, business enterprises, and involves other sectors, all the possible sectors, because at the end of the day, we are speaking also of a cultural change, like every time that we speak about human rights. So in order to achieve this, dialogue is fundamental. I believe that the reason why we did this today is because, as we know, we are holding the presidency of the Council of Ministers of the Council of Europe. So we are extremely happy that we have organized this meeting with the Council of Europe, and we were able to understand that the Council of Europe is using its knowledge in the field of human rights in order to focus also on the human rights and business. And they presented us also with a very interesting idea of creating a platform for discussion and for exchanging of best practices. I think that just to say that this is one of the many possible things that they may happen in the future. For sure, there is need of this. There is need of this dialogue among international organizations, among states and international organizations, and with the stakeholders. We know, we heard the Senator Martone, how is difficult the situation of the defenders of human rights. We heard from the other friends that were participating as multi-stakeholder, from Professor Fasciglione, from Professor Saborelli, and from Dr. Piatti, how complex is the issue when you start to look at it through the lens of the multi-stakeholder actors. So just to say that for us, this is one step. We hope that Italy has, with this initiative, has helped the progress of this very important field, one of the most, how can we say, one of the most energetic, one of the most interesting, one of the most active fields of human rights, is growing, is becoming more and more important. So human rights and business is something that we are all ready to invest on it, to bet on it. Italy has just released the second National Action Plan. We are starting to implement it. And I think that, I hope that after today, there will be developments. I hope that even if the Italian presidency will finish, we will be able to keep talking about this issue in the format, in the way that we have talked today, because it's clear that all the intervention made it clear that this is the way ahead, is to connecting the dots, is to create an holistic approach, is to have a dialogue. And so we are ready to do it. I say to our friends of the Council of Europe that please, we are ready to work with you again in future in these fields. And really, it is a pleasure. Finally, just to conclude, you know that I have a second hat. I'm also not only the president of the Interministerial Committee for Human Rights, I'm also, since 4 months, the special envoy of the Minister of Foreign Affairs for the human rights of LGBTQ+ persons. There are only 3 countries that have this so far: United States, Great Britain, Italy, and since 1 week also Argentina. I was in Argentina just 1.5 months ago, so that is very interesting development. I raised this issue because in the Italian National Action Plan that we just released, there was already in the first, but in the second one has been reinforced. There is a point, measure 22.5, in which we speak of the involvement of the business world, the involvement of, in the field of LGBTQ+. There are standards of the United Nations that were released in 2017, so it's a field that has already been started to be approached from different levels. So it just to say that also in this aspect, which is human rights and business for fighting discrimination against LGBTQ+ persons, Italy will try to bring its views, to bring its energies and its ideas, and let's hope that also in this way we can help human rights and business to become a really important tool for every person, for every category, starting from the most vulnerable ones. Thank you again to everybody. I would like to thank you, Professoressa Cristiana Carletti, that was helping me in this conference. I would like to thank all the persons working with me, that they helped me really today. But especially I would like to thank you again all the participants to the workshop. Thank you to have found time to be with us. Thank you for sharing your ideas in such an open manner, and let's hope that this path, as I said, will continue and will bring us in new ways to meet again and to find other possibilities, other actions, other ways of evolving in this important path. We know that the next 10 years, the United Nations Working Group has made a sort of roadmap for the next 10 years. So I think there will be a lot of occasion, but the whole point is to reinforce the dialogue. And so thank you again to be with us today, and see you soon.
Arrivederci, grazie.
Bye Fabrizio.
Grazie a tutti.
Thank you.